Recording has begun. Good evening. This is the January 21, 2025 special meeting of the Sunshine Ordinance Task Force of the City and County of San Francisco. The time is 5:59 p.m. The Sunshine Ordinance Task Force and its committees convene in hybrid meetings that allow for either in-person attendance or remote participation. Public comment will be taken on each item of the agenda. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Chair Yankee, that completes my announcements.
Okay, let's get started with item number 1. You can call the roll.
Item number 1, call to order, roll call, and agenda changes. We received advance word that Member Sugarman would not be attending this evening.
Okay.
We also have an item further on the agenda involving Mr. Petrellis, who will be unable to attend due to technical challenges. He has notified us. We have responded and said, please continue to attempt to join us.
Okay. Let's call the roll first, and then we'll discuss agenda changes.
Calling the roll. Taking the roll. Member Schmidt.
Present.
Member Schmidt, present. Member LaHood.
Present.
Member LaHood, present. Member Sugarman. Member Sugarman, absent. Member Kumar.
Present.
Member Kumar, present. Member Anderson.
Present.
Member Anderson, present. Member Highland.
Present.
Member Highland, present. Member Pilpel. Member Pilpel, absent. Member Wolf.
Present.
Member Wolf, present. Vice Chair Stein.
Present.
Vice Chair Stein, present. Member Chair Yankee.
Present.
Chair Yankee, present. 10 present, not 8 present. We have a quorum.
Okay, we have a quorum. Okay, regarding the Michael Petrellis complaint, that is item number 7, file 24056. We can see if he can join us and overcome his technical difficulties by the time we get to that. Another option, I'm not sure if he indicated one way or the other, but we can waive our rule and continue on with the hearing without petitioner if he so requests, or if we feel that that would be in the best interest. I believe he did attend the complaint committee hearing, so we have heard from him once. So we can discuss that when we get there, but just some things to keep in mind. Any other agenda changes from anyone? Okay.
Yes, we've been informed of.
Okay, seeing no hands, let's just double check and take public comment in case there is any.
Anyone wishing to make public comment on item 1, please approach the podium. If you're a member of the online community, please raise your hand in the app or press *3. I'll give you a moment. We have no one approaching the podium, no hands raised.
Okay, we'll go ahead and close public comment. No action taken, and we can move to item number 2.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force meeting of November 19, 2024.
Okay, I think everyone had these in several weeks' notice, and hopefully if you had any edits, you were able to send them to our administrator. Are there any last-minute edits? And if not, do we have a motion to approve these meeting minutes?
Move to approve the minutes. Member Wolf.
Okay, moved by Member Wolf to approve the meeting minutes. Do we have a second on that?
Second.
Seconded by Member Anderson. Not seeing any other hands, so let's go ahead and move to public comment if there is any.
Anyone wishing to make public comment on item 2, if you're in the room, please approach the podium. Members of the online community, raise your hand in the app or press *3. There is no one in the room and no one in the online community wishing to make public comment.
Okay, let's go ahead and close public comment and take a vote on that motion.
Taking the vote on item 2. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman, absent. Member Kumar.
Aye.
Member Kumar, aye. Member Highland.
Aye.
Member Highland, aye. Member Pilpel, absent. Member Wolf.
Aye.
Member Wolf, aye. Member Anderson. Aye. Member Anderson, aye. 8 ayes, motion passes.
I don't think you called me.
Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Yankee.
Aye.
Chair Yankee, thank you.
Mr. Chair, point of order.
Yes.
When the roll gets called, I believe our standard is to call the maker and the second first.
Yes. So it should be the maker, the seconder, seats 1 through 11, the vice chair, and then me last.
And second point of order, Member Highland, I believe since we know that Member Sugarman and Pilpel are absent, I think you can call the people that are here and at the end mention Member Sugarman absent, Member Pilpel absent. I don't think you need to go through the whole rigmarole. We've done that in the past, so if that'll help you.
Okay.
Member Wolf might think differently, but I think we've done that before, and I think it's apparent that they're not here for this meeting, so we don't have to mention them every time. But do mention at the end that they're absent at the end of the roll call.
Okay.
If it
Yeah,
helps.
that's cool. That's cool.
Okay. So that got approved. So let's go on, move on to item number 3.
Item number 3, approval of the minutes from the Sunshine Ordinance Task Force meeting of December 4, 2024.
Okay. Any edits or motion on this item?
I'll move it again. Member Wolf.
Okay. Moved by Member Wolf to approve these meeting minutes. Do we have a second on that?
I'll second it.
Seconded by Vice Chair Stein. I don't see any hands for comments. So let's go ahead and move to public comment on that.
Anyone in the room wishing to make public comment on item 3, please approach the podium at this time. We have no one approaching the podium.
Okay. Public comment is closed. Let's take the roll on that.
Member Wolf.
Aye.
Member Wolf, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Highland.
Aye.
Member Highland, aye. Chair Yankee.
Aye.
Chair Yankee, aye. 8 ayes, motion passes.
Okay. Moving right along, let's go on to item number 4.
Item number 4, Administrator's Report. Task Force and Committee Tentative Hearing Schedule, status of the 2024 mandatory training requirements, complaints and hearing requests, Sunshine Ordinance Task Force attendance, and communications.
Okay, let's deal with the upcoming hearings first. That's on the first page, item number 1 of the report. It looks.
Right. Item 1, upcoming tentative hearing schedule.
Member LaHood.
I had on my calendar, are we having a meeting on the 30th?
That's what I thought was decided. Did we still have?
Do we not have the room? Is that what it is?
I thought we had the room.
Oh, it's not on here.
Yeah. I don't know why that got dropped.
We do have the room.
Do you have?
I
enough
have
for
it
an
from
agenda?
4:30.
Yeah.
Yes.
We do have the room.
You have enough for an agenda and everything, right? You have, it's still worth proceeding.
Yeah.
Okay.
Yeah.
So Administrator Peterson, if you could work with CAC Chair LaHood and work on that agenda to make sure.
But actually, let's confirm that members Anderson and Wolf are still available for that date. Is that correct?
I will tell you in a moment. I think I left my phone downstairs when I
Oh,
went through
oh,
security.
oh,
so-
Oh, no.
Okay.
Okay. Member Wolf, would you be available that day? It's not on here, unfortunately. It got left.
Yes, I'm available on that day. It's already in my calendar.
So this is Thursday, January 30.
Correct. And just because that's an unusual date for us, you need all materials by the end of this week or,
5 business days.
yeah, okay.
Okay, and I believe member Pilpel is also a member of that, correct?
Yes.
Okay, so I'm going to make a decision now. Member Pilpel has not been in communication with any of us in over a month.
Mhm.
Because your committee has 4 members,
Mhm.
if he's not there, everyone else has to be there, otherwise you lose quorum.
That's correct.
So I'm going to officially remove member Pilpel from that committee since he's also on EOT. So that would make it the membership you,
Mhm.
member Anderson, member Wolf, and this way, if one of you 3 can't make it, you could still proceed.
Okay, and then assuming at some point you'll make communication with him and we can bring him back to the committee.
If somehow he makes himself known again,
Okay,
but his packet wasn't picked up. I've tried calling him, the administrators tried contacting him, and I'm not sure what's going on, but
okay.
in light of that, I don't want an inactive member to be
Right.
hurting your quorum. So,
For the record, we welcome him back
absolutely.
if and when he's available. Okay.
But I don't, in the interim, I'm
Right.
going to remove him from the roster.
Oh, look who's
Oh.
here.
Okay, never mind.
The devil.
We're happy to see you.
Okay, I cancel what I just said. Member Pilpel is present. No. Okay, we were just talking about, so I had just not hearing from you, seeing you, removed you from CAC, but if you still want to be part of CAC, I didn't know, since we didn't get the packet picked up, I didn't know if you were still around.
So just for welcome, Member Pilpel, we, in the packet, we're on administrator's report, and there's no, the January 30th meeting of CAC was not listed, and we were discussing whether everyone was aware of that and would be able to attend. And Chair Yankee said that he had not heard from you and was concerned about quorum, but since you are here, you can tell us if you are available for that meeting.
Sorry, I don't have the packet information.
No, it was in the drawer in the lobby.
Okay, so I need to get that.
The office is closed.
I can get you. Questions, 30 seconds.
This should have everything as a spare. If anyone from the audience needs it, we'll have to put it back. But that's the audience comment.
The first half of that binder is the task force packet. The second half is the complaint committee that was heard earlier.
So I just for this, while you take you can look at that, but right now we're trying to figure out if we'll have quorum for a special CAC meeting on the 30th of January. Is that something that you can make? If not, I can remove you from CAC roster since you're also on EOT.
I'm sorry, I'm a little. I I understood that there was the meeting on January 30th. We discussed that last year as a special meeting.
I did, but I had not included it in the administrator's.
So it
report
is
of
missing
future
from the
meetings.
administrator's report.
Okay, I haven't seen the packet material until now. So I'll still need to get a packet so that I have that for reference, but I'm available next week for both meetings.
Okay, you are. Okay, so I will withdraw my removal of member Pilpel from CAC, and he'll continue to stay on that roster. So we have confirmation that member Pilpel can make it, Chair LaHood can make it, member Wolf can make it, and member Anderson will be back momentarily, hopefully when she gets her phone. So we'll tentatively plan that. We can confirm when member Anderson gets back. While we wait for that, is there any other set of adjustments we need to make on these upcoming dates? Are any of those problematic for anyone? Good. Okay, it sounds like everything else is good. So we'll continue with the administrator's report before we conclude this item. We can come back with member Anderson's here. Okay.
Section 2 lists the complaints that have been received since the last task force meeting held on December 4, 2024. Matters have either been closed or have been moved to complaint committee. There was one item where we were unable to resolve discussions with the department, and the matter has been reopened. That is matter number 24064. Are there any questions about section 2? All right. Item 3 lists the pending petitions and complaints before the task force and the committees.
Okay. Okay, I do have a question about the pending ones.
Yes.
Not necessarily for you, Administrator Peterson, but just to clarify. So we had a file 23085, Spencer versus the district attorney. This went through CAC, and apparently there was a motion made at CAC. This was, I think, in August or sometime several months ago last year, about requesting advice from our legal counsel before it gets scheduled for a full hearing. And our legal counsel has been waiting for instructions on what legal advice we need. And I think there's been some confusion whether it's Chair LaHood or Member Wolf or who's the one who's going to work with our DCA to see what advice is needed. But I've been holding that one from our full calendar until that gets resolved. So since Member Wolf and Chair LaHood are both here, I thought I would ask, could one of you clarify what it is we need so our DCAs can prepare that memo?
And we did receive word from Member Wolf today.
You did receive word?
Yes.
Okay.
I thought
And
Member Wolf said to punt it to.
yes.
That
was the word.
Right.
Okay.
So I want to make sure we hash this out so that we can continue to move this. This is one of those ones that's been dangling out there for
Okay.
months.
I will have to, this was a while ago, I will have to go and look at that and see what that was about. And then we can proceed.
We
Okay.
have the section in the minutes that we can refer to you.
Okay, great. Thank you.
Member Wolf, did you have something to say?
I was just going to say, refer to either the minutes or the audio, because it was very explicit on how that was going to be handled.
If it was very explicit as to how it would be handled, could we just direct our city attorney's team to listen to the instructions in the audio rather than, or do I need to go back and type that all up?
I think our DCs are here. Oh, we have one here. Is it, if we need legal advice, could we refer you to an audio portion of our meeting, or do you prefer to have a specific written question submitted to you before you can provide advice?
I can't hear.
Oh,
Yeah,
you
we
use the microphone?
I'm sorry, I was just saying that it's more helpful to have a written questions because the audio might have just the back and forth in the discussion as opposed to having a set of questions of what's necessary for the DCA to brief and research.
And Chair Yankee, could you give me the number and the meeting you said that we made this decision at?
Yes, it is
October 23rd. 2023, I think.
And it's file 23085, Spencer v. District Attorney. And it looks like, based on Member Wolf's documentation here, that the discussion on the referral to their DCA for a question occurred between audio 1 hour and 47 minutes through 1 hour and 51 minutes.
I'll forward you that email.
Thank you.
And then the other comment I had on some of these pending ones is just so everyone is aware, there were several that were awaiting hearings. That was from one of our complainants, Mr. Zach Harnazes. We had some difficulties scheduling those matters. Mr. Carnazes has indicated he is ready to proceed on those. So we will begin to be scheduling his files starting in February. I think he has asked as an ADA accommodation to have one per meeting. So we'll do it that way. If there's any for the full task force, we'll get them to us. If not, we'll start them in through the complaint committee process or whatever else, what other committees have room to hear them. And that should, I believe, take care of any of the major ones that have been waiting. Go ahead.
I have a question regarding file number 22012. A former member of the task force was to draft a memo to the to COIT. It's an acronym for our computer group here at the city, and I do not have notes on what the memo was to be about. What is an approach for? Well, let me think here. I can check the minutes to find out what the request was of members.
We could work on that offline.
We'll work on
Yeah.
offline. Okay.
Yeah. If that member, you said it's a former member of the task force?
Yes.
Okay. So we have something we can't resolve here now. So you and I can work on that, Pat.
All right. Thank you.
What was the topic?
I do not know. I'll work with Chair Yankee and loop in whomever I have to. All right. Are there any questions about the attendance records that are in the administrator's report? All right, hearing none.
Actually, just to note, because I was looking at this, it looks like the absences in December are not highlighted. And so they might not be visible.
They are not.
Yep.
I will correct that. Thank you. As listed, are there any questions about the correctness of the items in December? Okay. Section 5 is a list of communications. I want to add that I've worked with Deputy Director Samara regarding responses to individuals who are writing about matters that are not relevant to the task force. Going forward, I will not be responding to items where the task force is not named directly. If we are CC'd, I will not respond. If we are directly addressed with a question, I will respond, but communications will not be included where we're just copied on matters that are not relevant to the task force.
Is everyone okay with that? Okay. Yeah. Most of these look like they really have nothing to do with us or nothing we can take any action on.
And my responses are included so that if there are any questions from you or from the public, you can see that we did respond.
Okay.
I did receive updates on completed trainings that were due by the end of the year, as well as one training that was due mid last year. Unfortunately, I didn't get a chance to review it. But I will take a look, see if there are any outstanding trainings, and if it's all right, Chair Yankee, I'll communicate with the parties.
Yeah, that's fine.
Okay.
And then I think probably all of us have the question, what can be done so that we're not receiving notice about hours and hours of training 2 or 3 weeks before the deadline? I mean, my understanding is that the system should be somehow automatically sending reminders to us when these happen. I checked the system, my email address is proper in there. I never received any automated message from the system saying that I needed to complete them throughout the year. I'm not sure if anyone else had the chance to go through that process, but
Well, one of the things that we were testing was whether or not the email address had been entered by you correctly into the system so that the system knew to reach out to you. Of those of you that I did hear from, you also indicated that you weren't getting reminders. I don't know why, and I don't know what else to check about why you didn't receive the reminders.
Perhaps it's because we don't have city email addresses.
That is not relevant. It's the email address that each of you individually has entered into the system about where you want to receive reminders. That said.
just out of curiosity, did anyone here receive reminders?
I mean,
Not from Pat. I mean, like from the system.
I think I did, but they didn't come in until December. So it's like we are giving this
right.
huge amount of work at the end of the year. It'd be nice if we could start it in September or October. And I think we would probably all get it done much earlier. I don't enjoy doing it, over my vacation time.
No,
I'd love to spread it out.
Yeah, 100%.
I also received a reminder quite late. I was speaking personally. I was dismayed to find out that one of the trainings was 4 modules in 2 hours.
Yeah.
That said, we will be checking more broadly about when trainings are due, and it'll be an internal reminder.
Yeah, I would say absent the system working, can you please check on a periodic basis manually and then let us know when those trainings pop up so we can start taking them when they.
Mr. Chair.
Yeah, go ahead, Member Wolf.
I receive other communications from the portal on a regular
DHR?
basis. Yes, I do.
May I ask, are they related to trainings?
No, they are not.
Oh.
They're related to other things. But they're automated.
But did you get
So I know my
reminders
email
about the
address is
trainings as
correct.
well?
Sorry?
Did you also get reminders about the trainings?
No, I did not get reminders from the trainings.
Thank you.
But I got other communications from HR other than trainings.
Thank you. I'll just add that to the bucket of facts.
Member
Kumar?
Highland here.
I'm probably ignorant about this, and I'm very sorry about it in advance. But when I did those trainings, when I first joined the committee a year ago, exactly a year ago, I was under the impression that I'm done and dusted with all the trainings. So is it possible to maybe get a list when you do get back to us on which trainings we may have missed, which ones are to be completed on a yearly basis or a quarterly or even a monthly basis, so that I can keep them on track in my calendar and I don't miss the deadlines?
Yeah, that's a great point, because I think some of them are annual, some of them are every 4 or 5 years, some of them, they do vary. You're absolutely right. So
Some are
Yeah.
every other year, some are mid-year, most are end of the year.
And I think there's going to be another one, the Sunshine and Ethics one, just so everyone knows. I think that's usually sometime in the early spring. I want to say it's March,
Unless it's a
April.
holiday, it will be due April 1st.
Okay, so
Now,
everyone
those-
knows that's going to be another one that's coming up that we're probably not going to get our automated reminder on, but there'll be, and it's an extensive 2-ish hour thing, if I believe.
The significance of those trainings is that they must be completed by the deadline. It is a different code section where you are required to take that. If you do not complete it by the deadline, you are not permitted to attend a task force meeting, and that includes being a member of the audience. You cannot participate. Participation includes being in the room and listening. That one, you will receive a separate notice from the Ethics Commission. They administer that training. Those 2 trainings. It's 1 module. It is online. Both trainings are required. April 1st of every year, unless April 1st is a holiday. Then it bumps to the next business day.
Member Highland here. I think I know why Member Wolf is probably getting HR notifications, probably because, Member Wolf, you had to go through the permission to be remote, and because of that, you made it into their system. That might be what's got you on their radar. That could be it.
Uh,
And secondly,
actually-
I wanted to,
I get healthcare through the city. That's why I get communications through them.
right. I think, yeah, I guess that too. Yeah. And then the second thing I was going to say is, since we're talking about this, and I think we did a bit of research, but given that the city doesn't quite know how to define us as a body, it might behoove, the chair or the vice chair to actually do a bit of research and see, A, what we are, and B, what trainings we really need. Because we don't really interact with too much of the city machinery. So I'm just curious to see, it'd be good to have someone take a look at and see, oh, okay, are you the same as these bodies, those bodies? What do we actually need, rather than, oh, let them just do everything, which is kind of where it feels like it is now, after all these years. And, sometimes I've heard, oh, we do need this. And then 2 years later, we don't need this. So over 12 years, I've seen it change. That line has moved. So it would be nice to actually talk to someone in wherever they are that makes these decisions and get some definitive, intel on where we stand.
So we are a policy body. I know the DCAs have confirmed that. And I did ask prior to, or when I first received all these emails about our trainings in this, I think it was December, for Pat to check and say, are these really all of them we have to do, particularly the technology ones, since we don't have city email addresses. And our administrator said she did check, and that because we do have access to the employee portal, that we are required to take it. I know that differs from prior years where we were told we didn't have to take it. Apparently now we do. I don't know why that's changed, but I did ask for them to check, and that was the word we received.
The current answer. Okay.
That's the current answer. So,
Mr. Chair.
yeah, go ahead, Member Wolf.
Yeah, just a clarification with regards to not if you haven't completed your Form 700s or the Sunshine declarations or the ethics trainings or stuff like that.
Yes.
It actually just disqualifies you from participating and voting on matters listed on agendas. It doesn't prohibit you from attending. And that's in the failure to file section 3.1-102.5 of the
Campaign and
conduct
governmental
of government officials and employees.
If there are questions, please contact the Ethics Commission regarding their recommendation regarding participation and what it means, if there are any questions.
Law.
Member Popo?
I'm sorry, I'm not having a good night here. I'm a little behind on this question of training. I agree with Member Highland that the requirements have changed over the years. I've always been of the view that we are subject to the Form 700 disclosure requirement, and we are subject to the Sunshine and ethics training requirements that go along with that. I have also been of the view that we're not subject to other training requirements imposed on city employees, because we're not city employees. We're city officials, but not city employees. We're members of essentially a border commission, but not employees. And so I think we should get some clarity in writing, not just a verbal explanation as to what these other training requirements are and under what authority they're imposed on us. Can we seek that?
Is that something, Administrator Peterson, you could work with, or is that a question for our DCAs?
And it's not a question to ethics, because I have no issue with.
I'm assuming you talked about the ones that came up in
whatever is being discussed, because I haven't seen any of this. Essentially, what I'm saying is, whoever is seeking to impose these requirements on us, we should, in my view, send an official communication to them or their department head and say under what authority do they believe that we're subject to these requirements. There you
Member
go. And
Hyland,
we,
this
and we
might be a
request a
good-
written response.
Yeah, this might be a good, maybe informal discussion with Angela, and then follow up with a formal to a DCA if we need to. But as Member Pilpel said, it seems like every year there's more stuff added to it, whereas back in the day, it was as
I think it's up to
posted.
4 or 5 of them now. There's the implicit bias one, which I know there was additional.
There was only one in the
Right.
day.
Right.
just
Now,
one.
now we're up
And
to
the
like I
700.
said, 4 or 5.
5, 6. Yeah.
And again, if we were paid employees who had time on the clock to do this, I would understand it.
Instead of doing
We're not.
Christmas holiday rushing. Yeah.
Yeah.
Yeah. So,
Family waiting in the other room. I'm like, wait a second, we have to do harassment training.
right. So and I do think we should ultimately get it in writing from Angela, from whoever, whatever. I'm not up to speed on all of this. I had a second point about the April.
Let me just pause you there. Administrator Peterson, is that something do you think you can work with clerk's office management to see if we can get some type of written document that shows what it is we need to take and why it is we need to take them?
Yes, with your permission, what I was going to do was request the manual that says this is your classification based on your role and the task force that you sit on, and these are the requirements based on that role. Would it be sufficient to provide you with that guidance, that written guidance initially, before asking any further questions?
Let's start there.
Sure. And we can, let's do this. Let's make sure that we put this item right in the administrator's report on our next meeting agenda, and we can hopefully maybe pick it up there if you can get that information to us in 2 weeks. And then we can decide if we want to make further inquiries. So does that work for now? Okay.
Well, I'm sure there'll be more.
Yeah.
My other point, since Ms. Peterson referenced the April Sunshine and Ethics training, in reviewing the ordinance, it does say that training as relates to sunshine should be done by the city attorney with the involvement, I forget what the term was, of the task force. And we have not engaged that role in many years. In as much as there is an EOT meeting next week, if the agenda hasn't been finalized, could we discuss that training and possibly invite whoever is coordinating that from the city attorney's office so that we might have some input on that content?
See our EOT Chair Highland, does that work?
Sure. I mean, that's something we've talked about in the past, and since we're doing this, it's probably a good juncture to bring that up.
I mean, on the one hand, if they're going to try to get us on training, we should engage on our part. And there are certainly things that we've discussed at this task force in the last year that might impact what gets included in that training.
Yeah, we've never been asked all the years I've been on. So,
despite the language in the ordinance.
right.
Okay.
Maybe we start with a letter offering, and then see where that goes.
Who will draft that letter, please?
But I think at this point, what we should do is just have that as an agenda item on EOT, and you guys can decide in EOT after it's been properly agendized how you want to proceed.
Well,
That's
and
a little off.
I'm just concerned that if we just have a brief discussion and then put it off till March, which is the next regular meeting of EOT, that'll be too late to impact it. So I would suggest that
I think this year's training module is already out. We're not going to impact this year's.
I don't know if it is or not.
It
but
is.
It was released
Yeah, it's already out.
first week of January.
So there's no time urgency. We're talking about 2026 at this point, right?
Well, then I just reinforce that I think we should invite whoever is coordinating this from the city attorney's office, and we could do that next week.
So
And
let's put
see
it
if
on the
they're willing to-
EOT agenda. I think that's a good place for this to start.
Yeah.
All right.
And you can work on the exact wording offline with Member Highland to see how he wants that written.
I had two other items on the administrator's report.
Okay.
With regard to the communications, I did recall in the last few days that there was some announcement about a settlement with the Bayview Hunters Point cleanup contractor. And I think and it was in the multi-millions. And it seems to me that that was likely a direct result of all of the work that Dr. Sumchai has done for many years, much of which has been included in the communications for some time. So I think there is some value to the communications, and just wanted to note that for
Regarding
the record.
Sunshine,
Sorry?
so that I understand, how does that matter apply to the Sunshine Ordinance Task Force?
That Dr. Sumchai has been communicating with the task force for some number of years about issues related to toxics at the Bayview Hunters Point in that neighborhood and the shipyard, and has brought several complaints to the task force over the years. And so I was just referencing the communications that were included.
I'm unaware of a pending matter.
I don't believe I think Member Pilpel saying that in the past she has had complaints before us. I'm not aware of any pending ones.
It's historical.
Just historical, as Member Wolf said.
Thank you for the comment.
So I was appreciating her work. And then finally, I know we discussed in December, following up on the ethics referral with regard to the mayor and the letter to department heads on transition that I believe I drafted in November. And I'm wondering if those two things were sent.
Yes, that was sent several weeks ago to the department heads, and I believe Member Schmidt, the ethics referral.
January 6th.
There you go.
Okay. Could we perhaps include the text of both of those in the next administrator's report? Not the, I assume the referral was at some length, but perhaps just the cover letter?
Not a problem. That's fine. It at least with regard to the letter to the Ethics Commission, I think, did we end up sending it out on behalf of the task force itself? I think we did. Or
It did not go through the task force.
I believe one from your email address.
that's right.
Yeah.
That's right. I assembled all the email addresses, and so all the members got it. I think that it was going to be provided.
Yeah, so Member Pilpel, that's something that you can receive a printout of. All the members should be CC'd on it.
I just think that those kinds of communications should get public visibility, and I think the administrator's report is a good place for that. Again, not the referral at length, but the cover letter. And when we finalize memos that we authorize,
The memo was posted online also, the one that was sent to department heads. So that's on our website under the documents.
okay, that wouldn't necessarily be obvious to me. Again, I'm just suggesting ways that we get more visibility for our work. And there was something, and the other referral that we had to ethics with regard to Chief Scott. Have we heard anything back from?
No.
Okay.
Member Schmidt, did you receive any type of you didn't even receive a receipt confirmation? Okay.
No.
I don't want to get too far off track since this isn't really an agendized item, but let me see what I'll do is just follow up on mine and see if I get some type of status update. We can see if Member Schmidt gets anything back, and then if we're wanting to have this as a further discussion about why we're not receiving updates back from ethics, we can agendize that and have a more robust discussion.
That's fine. And again, if we have a communication out to them, or if we magically receive something back, I think this would also be a good place to put that. Again, seeking visibility. What we do about it is a different question, agreed, but at least communications in and out. I think this is a good
if
place
we
for
receive
that.
an official reply back, this is the disposition of it, I'll make sure that that's included.
And in whatever communication you have with them, we would love to get both an acknowledgement and a periodic update. That would be, great.
I'm not inclined to put every communication in the administrative
No,
report.
not every, but those seem like they're high value. We don't make that many referrals. I'm done. Thanks.
Okay. Going back, remember, Anderson, you were going to check. Looks like you did get your phone, so that's great. I'm so glad you didn't lose it. The 30th, are you available?
January?
Yeah.
Thursday?
Yes.
Yes. Okay, thank you.
Okay. So make sure you follow up quickly with both member Highland and member LaHood so that you can get those agendas finalized quickly.
Okay.
And then make sure you touch base with me in the next couple of days for items for our next full task force meeting, which is only 2 weeks and a day away, so that those notices can go out in time.
All right.
That's a lot on your plate right now.
Okay.
Okay. Oh, and for the record, member Pilpel came. I didn't know if you had it at 6:14 p.m.
Thank you.
Member Highland here. Ms. Peterson, we already talked, right? We're good.
We are good. I have not heard from, I will speak with you offline.
Okay.
Yes, we are good.
Except for that agenda item, I think they're adding.
Yes.
6:15?
14. I have.
14. Thank you. If there isn't anything else, item 4,
Public comment.
5.
No,
Item-
no, let's see if there's any public comment on item number 4.
Item number 4, anyone wishing to make public comment, if you're in the room, please approach the podium. We do have a caller with their hand raised.
Okay.
One moment, please. Hello, caller. Do you wish to make public comment on item number 4, Administrator's Report?
Hi, this is Michael Petrellis. I'm abroad and don't know if my item is still on the agenda, even though I asked for a delay or a postponement.
I did see that postponement. I did respond. Good to know that you're here. You are still on the agenda, but you do not have public comment on item 4, Administrator's Report. Is that correct?
Correct, but should I stay on the phone because my item will be heard?
Yes, please.
While you're here, Mr. Petrellis, this is Chair Yankee. Has your technical issue been resolved? Will you be able to stay with us for the hearing on your item?
Yes, I can stay for the hearing if it is still on the agenda.
It is, yes.
Perfect.
Thank you.
Okay.
Administratively, can I confirm, are you on the landline or on your phone?
Unfortunately, it's a Wi-Fi phone connection.
Okay, so you are not available by text to confirm contact?
Correct.
Okay, got it. Thank you. Thank you very much. We have no other hands raised.
Okay. We'll close public comment, move on to item number 5.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Ordinance Task Force's jurisdiction, but not on today's agenda. Anyone wishing to make public comment, please approach the podium. If you're online, press *3 or raise your hand in the app. We have no one approaching the podium, no one online.
Okay, we'll go ahead and close public comment for item number 5 and move on to item number 6.
Item number 6, file number 23099. Complaint filed by Mark LaCroix against the San Francisco Fire Commission for allegedly violating Administrative Code Sunshine Ordinance Section 67.5 by failing to conduct meetings of any policy body open and public, 6710 for conducting a closed session hearing on a non-permitted topic, and 6711 by failing to properly notice a closed session hearing. On February 20, 2024, the Complaint Committee moved by Chair Schmidt, seconded by Member Stein, to find that the Sunshine Ordinance Task Force has jurisdiction and to forward the matter to the full task force. The committee requested that the matter be heard on the same day as File 23095, as the parties are the same and the issues are similar, but not the same. On August 7, 2024, the task force moved to find a violation of Administrative Code Section 67.10, B as in boy, regarding the January 12, 2022 Fire Commission meeting as to item 5C. The task force further found that in light of the previous motions, Member LaHood asked that the Fire Commission release the portion of the January 12, 2022 closed session pertaining to item 5C and requested a response from the Commission. On December 4, 2024, the task force, moved by Member Wolf and seconded by Member LaHood, referred and returned the matter to the Complaint Committee for consideration of a violation of Administrative Code Sunshine Ordinance 67.21. Lastly, on December 17, 2024, the Complaint Committee, moved by Chair Schmidt, seconded by Member Sugarman, referred the matter to the full task force with the recommendation to find a violation of 6721 and order production of the audio tape of the closed session that the task force has considered pertaining to item 5C. We have online Mr. LaCroix and Ms. Conifrey, promoting them to panelist.
Okay. And while you do that, I'll ask Complaint Chair Schmidt, did you have any updates for us based on what came out of your deliberations in December?
I don't think I have anything really to add to we've already been through. I think everyone knows what this is about.
Sounds good. Okay. So since we are hearing a new violation, I think it makes most sense to kind of conduct this as if it's a initial complaint. So I'm inclined to give each side 5 minutes, go through our process of questions. We'll do the rebuttals and then deliberation, unless anyone has any objections to that format. Okay. So we'll go ahead and we'll do 5 minutes first for the petitioner, Mr. LaCroix, and then we'll follow up with the respondent. So 5 minutes, if you can let Mr. LaCroix know when you're ready, Pat.
Mr. LaCroix, would you please unmute yourself? Thank you very much. Are you here?
I am. Can you hear me well?
We can. Are you ready for your 5 minutes?
I am ready. Thank you.
Your time begins now.
Okay. Good evening, task force members and chair and staff. The agenda actually summed up the situation pretty good. The task force already found that the session in question was not held under a permitted topic under 6710B. The Fire Commission had voted to keep this session closed. That is the only thing I saw on their initial response letter that was an unresolved issue. They claimed it was going to be illegal to release the session because they had taken a vote to keep it closed. I'm not sure if that's worth talking about. However, let's see. The Fire Commission, after you requested the record from them, went ahead and went in closed session again to get advice from the city attorney or a city attorney representative, and elected to deny the record to the task force, which I found interesting. So that led me to double back here, and I apologize it's taken so long. I didn't realize not complaining of 6721 impacted the ability to get a determination in this matter. So that's why we circled back and we're back here. So the only thing new I had pointed out, and I think Member Wolf had pointed out, 67.8-1A states that, quote, closed session recordings shall be made available when all rationales for closing the session are no longer valid, unquote. I think that's the only thing that I'm asking you to look at here, is there doesn't seem to be another reason for the Fire Commission to keep this closed session closed anymore. So I ask that you make a determination this evening whether the record is public. Thank you.
Thank you.
Okay, let's move on to the respondent when you're ready.
Ms. Conifrey, are you ready?
Yes, I am.
Your 5 minutes begins now.
Okay, I once again object to this complaint as it already has been adjudicated and previously a violation was found. Also, Mr. LaCroix just mentioned that it should be released because there is no reason to withhold it any longer. Well, that is untrue. Mr. LaCroix is a plaintiff in a matter in Superior Court, and he's suing the city and county of San Francisco and the fire department. And there is currently a stay on discovery motion that has been filed and granted back in 2023 while the 26 federal cases are pending a resolution. So that would actually involve this closed session hearing, as it is part of the whole crux of the Superior Court case. Also, this is probably what, your fifth or sixth time hearing this complaint. And back in, and I explained this at the last hearing, unfortunately, I believe there was only two of you there at the meeting that day. It was the complaint committee. But back in November of 2021, Fire Chief Janine Nicholson, at the health order that had come out requiring all city employees to get vaccinated, ended up having, I think it was somewhere around 24 letters recommending that the Fire Commission separate these uniformed members that had not been vaccinated. The commission wanted to hear these in the quickest manner and consulted with the city attorney's office to find out how they can go about getting these cases all scheduled in the most immediate manner. The city attorney's office had recommended going into a closed session, which was scheduled on January 12th, 2022. It was properly noticed. The agenda said that we could vote on whether to conduct items 5B, C, and D in closed session. The commission may hear items 5B in closed session pursuant to Government Code Section 54957.6 and Administrative Code Section 67.10C, and item 5C, which is what we're talking about, and 5D in closed session pursuant to Government Code Section 54957B and Administrative Code Section 67.10B. The commission voted to go into closed session and were under the impression that 5C would be, they could have confidential conversations. I don't know what their mindset was, whether, they were concerned about their own personal calendars, or some of the members who were referred on those letters for separation. A number of them actually got vaccinated. There were a fair amount, or a couple, that were on FMLA or disability, and we didn't want those names coming out. So they voted to go into closed session to figure out how to get these calendared in the most speedy way, and came out of closed session and voted not to disclose conversations that were, or discussions that were held in closed session. And at the suggestion of Member LaHood, we went back into closed session to re-vote on whether they wanted to disclose it. And once again, they voted unanimously not to disclose the audio tape from the closed session on January 12th, 2022. And here we are once again with a new violation, which to me says that we didn't respond timely, and we didn't.
Thank you, Ms. Conifrey.
Okay.
That concludes your time.
Okay. Members, do we have any questions? Member Pilpel, go ahead.
Okay. Question for Ms. Conifrey. I'll comment later, but this is just a question. Between the August 7th meeting of this task force, where we found a violation, and the December 4th meeting where the matter was referred or returned to the complaint committee. I believe that you informed us, it's not in the documents before us tonight, but that's fine, that pursuant to the request from Chair LaHood here, that you did bring the matter back before the commission and asked if the commission would waive privilege and disclose the tape or a transcript thereof. Is that correct?
That is correct.
Okay. Can you tell me what date that happened, and if someone here can pull up that agenda, and if you could, and if you have the agenda and the minutes, if you could reference those so that I can understand how those matters were calendared at that meeting?
I thought that was submitted, but it would have been the regular Fire Commission meeting, I believe on December 11th. They only had one meeting in December, regular meeting on December 11th. So I'm assuming that's the meeting that it was calendared.
Probably not, because I believe that you informed us of that prior to the meeting on December 4th. So I suspect it was prior to December 4th.
Then it would have been, there was only one meeting in November as well. So that would have been November 13th. So if it wasn't, yeah. I actually didn't get to talk at the December 4th meeting. There was no questions asked of me, and I never spoke at that December 4th. So I believe it was the December 11th that we brought the matter back to the Fire Commission. But I'd have to go on to our website and check that.
If someone can check it while we're having this discussion, that would be great. I was of the...
Somebody is, as in your people, or?
I'll check.
Thank you. Somehow I got the idea that you did bring it back there and that the commission declined to disclose, but
that is correct,
follow up
yes.
with the request. Okay.
Yes, that
so
happened either in the November or the December meeting.
Okay. So what I'm now trying to explore is how that was calendared and what the essentially what the item was there. If it was, I presume, in closed session.
Correct.
To discuss whether or not to disclose, because it's just highly unusual to have a request to disclose a closed session tape or transcript thereof or any portion thereof. And so I'm interested in how that would be calendared at a commission, but presuming that was done correctly, legally, whatever, that's the commission's position.
Right. And the city attorney's office was there to guide the commission on why it was back in front of them.
That's fine. And I think I stated at a previous hearing that I appreciate that you did bring it back. Although I still believe that the original closed session was improper in 2022. I'm just trying to explore how this latest phase was handled. Chair Yankee?
Yes. Okay. So I'm not sure why the entire packet from before didn't continue along the way, but this letter was part of the packet that we heard last time. So it's part of the record, so everyone hears it. I have it in front of me now. This is the letter from Ms. Conifrey to us, dated November 15th, 2024. I'll read it. It's only 2 paragraphs.
Okay.
It says, at the Sunshine Ordinance Task Force meeting of August 7th, 2027, I'm assuming that was supposed to say 2024, but it says 2027. And then it continues, the task force found the Fire Commission was in violation of Administrative Code Section 6710B regarding the holding of a closed session under item 5C of the Commission's January 12th, 2022 meeting. Following that decision, the task force approved a motion to request that the Fire Commission release the recording from the closed session. The Fire Commission considered the task force request at the Commission's November 13th, 2024 meeting.
Okay.
After due consideration of the request and by a unanimous vote, Fire Commission decided to not release the closed session recording. The Fire Commission's decision is in line with the position taken in prior correspondence with the task force on this issue. We appreciate the task force perspective on the issue, but believe it is lawful to withhold the closed session recording. That's what the correspondence said.
Okay, I appreciate that. So I guess what I'm trying to figure out in my mind, and I think I will try to form a question around this, is whether the task force, even if it feels that this recording or a transcript thereof should be made public, whether we actually have the authority to order it. I understand if it's a document, we can order disclosure. To the extent that this is a record, a closed session recording, for which there is no transcript at this time, presumably, I tend to think that it's more government.
This sounds more like deliberation than a question for the petitioner or the respondent. I want to keep this just on petitioner respondent questions for now.
All right, then let me follow up with their deputy city attorney when we get to deliberations. Okay. I think that's where I'm headed. All right.
Member question.
Member Lopez, then was it Member Wolf and then Member Kumar?
Yes.
Okay.
I don't know if this would be helpful, but their Member Pilpel had requested what was on the agenda for that meeting. Do you want me to read the item or that section thereof into the record?
Sure.
Okay. So there were 6 items, and then it comes to closed session, roll call. Item number 7, conference with legal. Oh, first there was a vote on whether to conduct items 7 and 8 in closed session. And then item 7, which is what we're talking about. Conference with legal counsel, existing litigation, request for release of closed session tape. California Government Code Section 54956.9D1, San Francisco Administrative Code Section 67.10D1, discussion and possible action. On January 12, 2022, the Commission held a closed session on the status and calendaring of pending disciplinary and separation cases. Following a public records request from Mark LaCroix for the closed session tape, which was denied, Mr. LaCroix filed a complaint with the Sunshine Ordinance Task Force, which found that the tape should be released and has requested that it be released. The Commission will discuss and act upon the task force request to release the closed session tape. Mr. LaCroix is one of the plaintiffs in the litigation case against the city regarding the COVID-19 vaccination mandate. The case is Michael Cricken et al. Versus City and County of San Francisco et al. San Francisco Superior Court, case number, I'm not going to read it, filed June 13th, 2022. This task force complaint is Mark LaCroix versus San Francisco Fire Commission, file number 23099, filed December 7th, 2023. Then there was another item in their closed session. They reconvened in open session, and then they had a vote in open session to vote to elect whether to disclose any or all discussion on item number 7 held in closed session, which was the one that was referred to. So I think that's everything relevant to this.
Thank you very much.
Okay, thanks. Member Wolf and then Member Kumar.
Yeah, I have a question for the petitioner and possibly for the respondent, depending upon the answer. Mr. LaCroix, did you request a public hearing before the closed session was announced?
No, and that's part of the problem is let's see, I forget which section of Sunshine Ordinance is. It's early in there.
Section 6710B.
Oh, yeah. Well, that's the violation you found. So there's another section that says, is the agenda, is the subject matter able to, like a person of normal intelligence, able to understand it and determine whether they should, it's an item of interest and they should pay attention. Well, status and calendaring, didn't particularly pique my interest at the time. However, in the commission's initial response to the complaint, they stated in there that they were actually discussing our dismissals, which is inappropriate to happen before a hearing. And that, I believe in the last session with you guys, I kind of went into the good government guide where it says that commissioners are not allowed to discuss pending matters before evidence is taken. So They didn't actually do, it sounds like, they did more than any status and calendaring. They admitted they were discussing our separations. So to answer your question, no, I wasn't attending this meeting.
Were you notified that you could have the item heard in a public hearing?
So no, there was no 24-hour notice under the Brown Act that any sort of charges were going to be discussed or anything like that.
Okay, Ms. Knopfrey, did you receive any communications regarding a request for public hearing on a closed session matter like this?
Not that I recall, no.
Okay, what was it? Was the complainant notified that they had the right to a public hearing?
No, because it wasn't regarding. It was regarding scheduling of matters that they wanted to get on calendar. It wasn't the crux of anybody's individual complaint. It was just to figure out how to get these scheduled in a timely manner.
And you are holding a closed session for the scheduling?
We were for the scheduling of these matters and the commissioners' personal calendars and, things that we were advised by the city attorney's office that we could discuss in closed session.
If I may interject, Member Wolf, you were not present when we first heard this regarding the closed session line of questions. We already kind of went down this path and decided that there was a violation.
Right. Okay.
This is at the August step. So this hearing now is not to relitigate whether or not there should or should not have been a closed session or whether or not there was a request from Mr. LaCroix specifically about, I want a recording of it. And so when Mr. LaCroix first came to us with his complaint, he asked us in his intake form to only make a ruling on whether or not the closed session was appropriate. He failed to include a request to us for an order to produce the recording. So we had our hearing, found that there was a violation, that there should not have been a closed session that took place. That was a violation.
Okay.
He subsequently has asked now, based on the ruling that we said that closed session should not have taken place, now he wants a copy of the recording. So I just want to make sure we kind of focus on that public records piece, not the closed session piece.
Gotcha.
And there's also a stay of discovery in a court matter.
Member Wolf, go ahead. I'm sorry.
I was just going to ask. So we're just looking for a document at this point.
Well, right, we're looking for the recording.
Looking for the recording. Okay.
Or record. Yeah.
Or a transcript.
Or transcript. Right.
No transcript. Otherwise, somebody would have to listen to
the assertion by the respondent that because this is, discovery has been stayed. Is there any evidence of that? Is there anything from a court in writing that shows that?
There sure is.
Is it in our record?
No, it's in the docket, the court docket.
Okay, so we don't have
There's a hearing actually on the 24th to have it lifted by Mr. LaCroix's attorney.
But we don't have that evidence.
I didn't give you that evidence. I just read it into the record.
I don't think that's.
And it was put on the agenda that Ms. LaHood just read to you, the Fire Commission's agenda. It had the court number and everything on there.
It'd just be good to see what the details are of the stay. What discovery is being restricted?
Yeah, I'm not an attorney. I can't advise you on that.
Does that conclude your questions, Member Wolf?
Yeah, I would. It's hard to kind of accept the answer because there's no corroborating evidence. That is part of a public process.
Okay, I'm going to move on to Member Kumar then. Go ahead, Member Kumar.
I'm playing catch up here because I missed the December meeting, but I'm just curious. This is a question for you, for the chair. Has it been cited that the record won't be released by the fire department because of an additional anticipated litigation?
So I read what I read was what the official response was. I'll read it again. That paragraph says the Fire Commission considered the task force request at the Commission's November 13th, 2024 meeting. After due consideration of the request and by a unanimous vote, the Fire Commission decided to not release the closed session recording. The Fire Commission's decision is in line with the position taken in prior correspondence with the task force on this issue. We appreciate the task force's perspective on the issue and believe it is lawful to withhold the closed session recording. But that is a good question.
Can I just ask that to the fire department?
Yeah.
Okay. Hi, ma'am. So the question for you is, are you refusing to release the recording because you're anticipating further litigation?
First of all, this is the Fire Commission, not the Fire Department.
Sorry, my bad.
That's okay. I just want to not confuse things here. Can you repeat your question?
Yes, ma'am. My question is for the Fire Commission that are you refusing to release the recordings because you're anticipating further litigation in the matter?
No, it's because the Fire Commission voted to not release it.
So I have a kind of a follow-up question for you, Ms. Confrey, on that. So my understanding is that this is all based on the closed session initially that occurred on January 12th of 2022. But you mentioned that there's now litigation. So my question to you is, what is the litigation? Did the litigation commence after the initial closed session that we're talking about?
Yes, it did.
It did. Okay. So there was not pending litigation at the time that this closed session occurred.
No. Wait.
No.
Which date? Can you be specific?
So, the January 12th, 2022.
Yes.
This is the initial one that Mr. LaCroix wants his recording of.
Mr. LaCroix was still an employee at that point.
Okay. So there was no pending litigation on January 12th of 2022.
That's right.
So
not involving this matter.
I mean, right. We're not involving this matter, right? There was no pending litigation between Mr. LaCroix and the Fire Commission on January 12th, 2022. Right. Is that correct?
That is correct.
Okay. So the closed session, just so everyone's aware, this closed session was not to discuss pending litigation on January 12th of 2022. Right? That's not the reason given for closed session on January 12th of 2022. We've already litigated. Yeah, we've already kind of been over this. I want to make that clear.
But Member Kumar's question was at the November 13th, 2024 meeting, was the reason for non-disclosure that there may be further litigation on the matter. And I think Ms. Conifrey just said that there was no stated reason, just that the commission decided not to disclose. There was, in fact, a pending
There was
litigation.
closed session discussion.
Right.
With an attorney.
There was pending litigation at the time, but that wasn't and that was partially the basis for the closed session. But the commission made a decision 2 months ago in November, but didn't state a reason publicly. They just said, no, we're not going to disclose.
Yep. Well, just out of curiosity, when was the litigation, when was it filed? Ms. Conifrey, and I apologize if you had already answered this.
I believe in 2023. Mr. LaCroix should know, he's a party to the lawsuit.
Okay, Mr. LaCroix, when did you initiate litigation?
I believe it was June of 2022.
Right.
June 2023.
It says so on their agenda.
Okay, so just to make sure kind of we all understand the timeline, your initial public records request was dated December 7th of 2023. And this is when it says, dear, I think that date was wrong.
No,
I'll try to
that
find the
date's
initial
wrong.
one. November 22nd, 2023. This is the initial request that we're dealing with right now for the request for the public record. It was dated November 22nd, 2023 to Maureen Conifrey, Fire Commission Secretary, from Mark LaCroix. Subject line regarding public records request says, Dear Ms. Conifrey, I am requesting the following records from the San Francisco Fire Commission. January 12th, 2022, Fire Commission regular meeting. Any and all video audio recordings as well as transcripts of the closed session referenced by agenda item 5C. So on November 22nd, 2023, there was in fact pending litigation at the time you submitted the public records request, but not pending litigation when the initial closed session meeting occurred. Is that correct? I just want to make sure I established the timeline correctly.
Your timeline's correct. However, I think it's notable that the Fire Commission is not named in our suit or any of the fire commissioners, and this is not discovery material. It's simply a public records request. And also what might help clear this up is 6724BII. Let me read that guy to you. This is for litigation material. And II is a record previously received or created by a department in the ordinary course of business that was not attorney-client privilege when it was previously received or created, that shall be disclosed as a public record. So it sounds like
you answered my question. I think we're good.
Okay, great.
Vice Chair Stein, I think had a quick. Okay. Anyone else with questions, or should we move to rebuttals? Go ahead, Member Kumar.
I'm just wondering how, so in 67.8.1, we are saying that the Sunshine Ordinance says that justification, I mean, the rationale for not releasing a recording can be anticipated litigation 2 years after the meeting if no litigation is filed. So if we go by this verbatim, it sort of does justify the Fire Commission not releasing.
That sounds like a deliberation thing. So if you don't mind, I'm going to hold that until we come back for deliberations.
Okay.
Unless it's geared towards the petition of the respondent.
No.
Okay, let's hold that thought then. We'll move on to rebuttals, and then we'll come back and we can talk about that. All right, so let's do rebuttals. We'll start with the respondent for 3 minutes, then the petitioner for 3 minutes, and then it's us to figure out how we want to handle this.
Okay, well, I think
your time begins now.
Okay, I think you've heard this matter over and over and over again, and I really have nothing to add than what has already been said previously over the last 5 or 6 meetings. So I will leave it at that. Thank you.
Thank you.
Okay, thank you.
Mr. LaCroix, are you ready for your 3 minutes?
Yes, thank you.
Your time begins now.
Okay. Yeah, it sounds like the new issue just brought up this evening was not in the response letter from the Fire Commission from their November meeting as a reason for withholding the record. It seems to be a new issue just brought tonight. And I think it's notable that the Fire Commission or any fire commissioners, none of those are in the litigation. So also on rebuttal, the original Fire Commission response, I know Maureen was saying was status and calendaring is what they were doing. They actually were doing a little more than that. Let me find this real quick if I still got a minute. Here's what they said. Let's see, here's a quote from their initial response. The commission went into closed session to discuss dismissals of specific employees, one of whom was Mr. LaCroix, unquote. So maybe that clears up some of the issues here. The Fire Commission is not in litigation. I'm not in litigation with the Fire Commission or any fire commissioners. Thank you.
Okay, thank you.
Thank you.
Okay, so just to kind of frame this for everyone, since I know we had three members who were absent when we first heard this, just again. So where we're at on this, to kind of springboard into deliberations, is we already decided that there was a violation of the Sunshine Ordinance, that the closed session that occurred on January 12th, 2022 should not have occurred. And that was under 6710B that we found the violation. So I think what we need to decide now is if we decided that the closed session should not have occurred, and someone now is asking for a record associated with that closed session, do we have the authority to now issue an order to produce that record under 6721? I'm not sure I have the answer, but I think that's kind of where we're at, so we don't get too far off track. Is that for those of us who are here?
That's essentially what I was going to ask our deputy city attorney, and more specifically under 67.21E. It's and I guess I can preface that by saying, although this is stylized as a records request, which it is, it pertains to closed session records. And so that leads me more to the Brown Act and how closed sessions are handled in the Brown Act and disclosure thereof and restrictions on disclosure thereof than to the Public Records Act and Article 2 of the Sunshine Ordinance. Article 2 versus Article 3. So can you give us your view on whether, given where we're at, as Chair Yankee just articulated, if you think we have the power to order disclosure of the tape, a portion thereof, or a transcript thereof at this point?
So unfortunately, I'm pretty new to this issue, and it sounds like you're talking about some.
Sorry, is the mic on?
Could you speak a little closer?
Okay. So unfortunately, given the fact that it sounds like there's a lot of water under the bridge on this particular issue, and because it involves potential complex interaction between the Brown Act and the Sunshine Ordinance, I don't feel like I'm well situated to say something on the fly regarding this. I'm more than happy to look into this and give you something in writing, but at this point, I wouldn't feel comfortable doing that. And I also would like to confer with my colleagues to see if a similar issue has arisen.
Okay. So I guess where I'm at, and I'm open to being persuaded here, I stand by my prior view that the closed session in 2022 was inappropriately calendared and was not held appropriately. I'm not sure, and I tend to think that we cannot order disclosure of records from that session. I think that gets into that interplay between the Brown Act and the Public Records Act as further enhanced by the Sunshine Ordinance. So my thinking is that while there is existing litigation between Mr. LaCroix and it sounds like others versus whoever, because I haven't had a chance to look up that case yet, that whether in the context of that case or as a separate matter, that the parties could brief and litigate the issue of the closed session, whether it was properly held, and what remedies exist in court to compel disclosure. But I'm not sure that under the Sunshine Ordinance that we have the jurisdiction tonight. And again, I'm open to persuasion, and my colleagues may feel otherwise, to order disclosure of the tape, a portion of it, or the transcript thereof, unfortunately.
Okay. Thank you, Mr. Member Pilpel. Other thoughts? Member Wolf, go ahead.
Yeah. So a few things. One is, just because a policy body's taken a position of not disclosing a record doesn't mean it's correct, despite legal advice. If we find that the record is public, then it's public. The other thing is, I think along the lines of Member Kumar, is that since there hasn't been any litigation, and by the testimony of the petitioner that he's not involved in any litigation involving the fire department or the fire commission, that leaves them not party at all in general. And I think that 67.8-1A is still stands with us. Also, you know, an agenda is a public record, minutes are a public record, recordings are a public record. It's not the section regarding public meetings is about the operation and the commencement of a meeting and how it operates, but all the documentation that is applied in a meeting is a public record. So I don't I would say, in my assertion, is that 6721E in the middle, where it says upon determination that the record is public, the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request. And I think that that's where we need to go. I'll stop there.
Thank you, Member Wolf. I have Member Schmidt and then Member Kumar.
I would support what Member Wolf has said to us. I don't think that we can, without some specific actual reference to something in the Brown Act or in Sunshine, that somehow it modifies the CPRA, modifies the document provisions in Sunshine. I think we just look to the CPRA and Sunshine here. And this, we already have said it's a document that came out of a session that we believe should not have been closed. I don't think there's any real complexity to that. And just one other thing, which is I don't think there's any reason to be mystified by maybe there's litigation and like that kind of makes everything mysterious or like, oh, they're litigating, so we can't do anything. There's no reason why litigants can't file public records requests. They do it all the time. If somebody showed us some kind of an actual order of a court, an actual court rule that would say that, you know, discovery's closed or something, you know, nobody can do anything of a certain kind, then we'd have to be concerned. But there's just sort of maybe vague allusion to, oh, maybe somebody sued somebody else. I think there's no reason to really give that much concern or thought here.
Member Kumar.
I found a copy of the case, the lawsuit, and even though the Fire Commission is not named as a defendant, if you scroll down on the 32nd page, it's actually said the plaintiffs are actually asking for relief and judgment and naming City and County of San Francisco Fire Department, the San Francisco Fire Commission, and two employees to refrain from further discriminatory acts. So they are named in the lawsuit. Just wanted to point that out.
Thank you. Member LaHood.
So here's an interesting thing. If we already determined that the meeting should not, or that portion of the meeting should not have been held in closed session, so there was an error there. So it shouldn't have been in closed session, even though there's pending litigation by Mr. LaCroix. if someone else filed a records request seeking the recording or the transcript of that meeting, since we already determined that it shouldn't have been that there shouldn't have been closed session, if we were to say, if we would vote to give anyone else access to that, I think we have to vote to give Mr. LaCroix access to that, because his pending litigation doesn't have anything to, I mean, that's why he wants it. But if he had filed this anonymously and we would say, yes, the record needs to be released, then we need to release it to Mr. LaCroix.
Yeah, I'll jump in. I'm really compelled by what Member Wolf and Member Schmidt and what you just said. I think that this is actually kind of simple, is that Mr. LaCroix is asking for a public record. And we ruled that the exemption claimed by the Fire Commission is not a valid exemption. In this case, they said it was held in a closed session. Well, we said it shouldn't have been in a closed session. So if it would have been an open session, it would be disclosable. And it says if it's a public record and it's not exempt from disclosure, we should order its disclosure. So I don't think the litigation really matters, like you said, one way or the other. If Mr. LaCroix had asked for meeting minutes of an open meeting and had litigation, you turn it over. It doesn't really matter whether or not there's litigation. So we said this really should have been an open meeting type of thing. We have the authority under the Sunshine Ordinance to turn it over, and so I'm very compelled by that. The only thing I'd note is basically the difference is before we asked them to turn it over, now we're going to order them to turn it over. I'm not sure that ultimately is going to matter. I'm sure the Fire Commission will go back and meet with their DCA in closed session, and then they'll probably still say, no, we're going to violate your order. And then this is where it gets really tricky, because the Sunshine Ordinance does not include commissioners under those people who can make a willful violation of the Sunshine Ordinance. So we could ask the Ethics Commission, if this plays out how I'm assuming it will, and I'm assuming that even though we now call it an order this time, they're still not going to turn it over, probably come back to us. We could ask the Ethics Commission to get involved. I'm not sure to what extent the Ethics Commission may or may not want to get involved in this. Just something to keep in mind, but I don't think that really matters on our vote on the order tonight, but just kind of throwing that out there. Member Wolf, your hand is still up. Did you have another comment?
Yeah, I just wanted to mention, I appreciate Member Kumar's research to find the actual case, but I just would caution that we not include items that are not currently in the record, especially during a meeting. This is really a responsibility of the parties to be able to bring that information forward. And since it was given to us verbally by the respondent, but not in writing, no, as you mentioned, Mr. Chair, there's no written court order in front of us. I think we need to disregard what was iterated with regards to that.
Okay. Member Popel?
Yeah, several things. I think there are at least three kind of interrelated and overlapping issues here. One is Mr. LaCroix's employment status with the city. The second is the public meeting of January of 2022 at which the alleged thing happened. And the third is the tape or record of the closed session held at that meeting, which is a public records issue. So it's employment, public meetings, and public records. I would like if we had more clear authority to order a remedy to a meeting violation in the ordinance. I don't read that. I don't see that there is the same kind of language for an Article 2 violation as much as an Article 3 violation. All of the powers that we've been using, as far as I can tell, are in this case are 21E powers, which are Article 3, not Article 2. I mean, if anything, it's the district attorney that could get into this and say, taking a deposition, the DA's office agrees with us, for example, and wants to review the closed session and get into that. I don't know that that's likely here. I think, and I wanted to point to Section 54963 of the Brown Act, that confidential information disclosure from closed sessions is generally prohibited. So even if we think that the closed session was improperly handled, neither Ms. Conifrey nor members of the commission nor anyone else can disclose confidential information that they got from that closed session. That would be a specific violation of the Brown Act, and pretty much frowned on. So that's why I opined earlier that I think the only remedy for Mr. LaCroix, beyond us and our opinion, which was, I think, well considered, is to seek a remedy in Superior Court. They have the ability to order certain actions related to closed sessions that I think we don't. And so that's where I think they can go. And I think that's unfortunate. I think that informs perhaps some of our discussions about rewrite of the ordinance, about powers and duties. I did find it interesting on the agenda for the Fire Commission meeting in November, 2 months ago, that suggested that this task force, I guess, is operating in a adjudicatory or quasi-adjudicatory capacity to hear this. So that's interesting. But I still don't think that it gives us any new power here. And I just, if we start to get into the position of saying that a closed session was improperly calendared and therefore we're ordering disclosure of a tape, whether it's the Fire Commission, or any other board or commission, Board of Supervisors, whatever, I think we get into very tricky water, and I don't know that we have a good legal basis to be there. I think that's different from ordering disclosure of a record that's unrelated to a closed session. But I think when you get into a closed session document, and to Member Wolf, just briefly, I think you said that any document related to a public meeting is public. I don't think that's entirely true. If there was a proposed settlement report or some other confidential document provided to members of a board or commission in connection with a closed session item, that would not be subject to disclosure. And I don't think we would be in a position to review it or order disclosure of it. So I just think there are some very tough legal questions here, and that's where I'm at right now. Thanks.
Mr. Chair.
I have Member Schmidt, then I have you, Member Wolf.
Okay.
I'd like to make a motion that we find a violation of Section 67(2)(1) and order production of the audio tape of the closed session at issue here.
Okay. We have a motion from Member Schmidt. Is there a second to that motion?
Second.
Seconded by Member Wolf. Okay. Now, Member Wolf, did you have a comment?
Well, yeah, I just wanted to, I appreciate what Member Pilpel said. I don't necessarily agree. If records in a meeting were being withheld because of confidentiality, it doesn't mean that they're not public records. It just means they're not disclosable. There are other records which can be deemed not public, but public records that have information that is not to be disclosed would be redacted. It's still a public record that can be disclosed. And I'm also concerned with regards to, I'll come back to Member Kumar's assertion of 67.8-1. We need to be able to focus on when either the alleged violation or the actual violation happened, not with what's happening today. The complaint was made how long ago, and the complaint of a violation was made a long time ago, and that is where I believe we need to be focused on, unless there's some other extenuating circumstance that brings current information to the fore. But at the time that the complaint was made, it sounds like there wasn't any anticipated litigation at the time, and has it been 2 years after the meeting? And was there any litigation filed since the time of that original meeting happened? And if not, then I think 67.8-1 applies. And that is regarding audio recordings and video recordings of the closed session, which would also include the transcript. So I just want to make sure that was in the record. Thank you.
Okay, thank you, Member Wolf. Any other comments before we move to public comment on the motion? Not seen any other hands. Let's go ahead and move to public comment on that motion.
Individuals in the room, if you would like to make public comment, please approach the podium. Members of the online community, please raise your hand by pressing *3 or using the app. We have no one approaching the podium, no hands raised.
Okay, we're going to go ahead and close public comment and move to a vote on that motion.
Can you restate the motion
sure.
so it's very clear?
Can you reread the motion, please, Administrator Peterson?
Moved by Member Schmidt, seconded by Member Wolf, to find a violation of Administrative Code, Sunshine Ordinance 67.21, and order production of the audio tape of the closed session at issue here.
I'm sorry, can we just clarify at the end, not to say just at issue here, but the closed session of the Fire Commission of January 12th, 2022, item 5C.
Sure, that's fine.
Not trying to change anything, just so that it's very clear, because this may end up as part of the litigation, and I don't want it to just say at issue here.
Sounds good.
An order production of the audio tape of the closed session held January 12, 2022. Closed session of the Fire Commission held January 12, 2022.
Item 5C.
Item 5C. And Member Wolf is a seconder. Are you okay with that change?
Yeah, that's fine.
Okay. Okay.
Production of the audio tape of the closed session of the Fire Commission held January 12, 2022 regarding matter 5C, period.
Okay. Let's go ahead and take the vote on that.
Member Schmidt.
Aye.
Member Schmidt, aye. Member Wolf.
Aye.
Member Wolf, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Highland.
Aye.
Member Highland, aye. Member Pilpel.
No.
Member Pilpel, no. Vice Chair Stein. Vice Chair Stein, aye. Chair Yankee.
Aye.
Chair Yankee, aye. 7 ayes, 1 no.
Okay. Thank you. 8, oh, yeah. There's 9 of us here.
8 ayes.
8 ayes,
8
1
ayes,
no,
1 no.
1 absence. That gets to 10. Yeah. Okay. Thank you, Mr. LaCroix. Thank you, Ms. Confrey. Let's go ahead and take like about we'll call it a 9 or 10 minute break. We'll come back at 8 o'clock and then finish up the meeting.
Chair Yankee,
Yes.
does Administrator Peterson need to say who was absent attached to this vote?
Yes, it needs to be listed as part of
No,
the roll.
but do we need to say it?
We probably should say it on the record, so it should say
Who was
one
absent?
absent member Sugarman. You don't actually have to call his name, but you should say it, so it's part of the audio record.
1 absent member Sugarman.
That works.
Thank you.
If Mr. Petrellis is waiting, should we not
Let's
take
take a
his?
quick, I want
All
to make
right.
sure everyone has a chance to get that fine. So, right. 4.
Mics are off. This is Clerk Peterson. I see 1 hand raised in the online community. I don't believe your hand was raised when we called for public comment. Can you please confirm? I'm going to unmute you. Can you please confirm whether or not you wanted to make public comment on this item? Hello, caller. I did not see your hand raised. Did you want to make public comment on this item? Hello, caller, you're unmuted. Going to the next caller.
Hi, it's Michael Petrellis. I'm ready when you are.
Oh, Mr. Petrellis, we will be with you shortly. We are taking a quick break.
Okay.
So you are at the item with the prefix 996.
Yes.
Okay, we'll be in touch shortly. The microphones will be
Okay.
talked. Thank you. The microphones are on. The time is 7:59.
I've 8:01.
Caller parties present.
I've 8:01, just to keep the same.
8:01.
8:01.
Sorry,
8:01.
My clock apparently doesn't match exactly this clock, but I'm using the same clock, so at least it's the same.
They're all different.
Yeah,
Yeah.
they're all different.
My computer matched your phone.
Yeah, it might, yeah, matches the phone. Okay. Yeah. Anyway, okay.
8:01 p.m.
Okay, item number 7, where we left off.
Item number 7, file number 24056, complaint filed by Michael Petrellis against Andrea Iao, Castro Community Benefit District, for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a records request in a timely and/or complete manner, and 12L4C, sub 2, by failing to allow for at least 30 minutes of public comment at each designated public meeting. On December 17, 2024, this matter was heard before the Complaint Committee for a determination regarding jurisdiction required prior to scheduling a Sunshine Ordinance Task Force hearing on the complaint, pursuant to Administrative Code Section 6721 or 12L4C sub 2, or referring the complaint to the city agency who administers the contract for the Castro Community Benefit District, pursuant to Administrative Code 12L, Nonprofit Public Access Ordinance. The Complaint Committee, moved by Chair Schmidt and seconded by Member Sugarman, referred the matter for consideration by the full task force with a recommendation of a finding of no jurisdiction over the Castro Community Benefit District and no ability under Administrative Code Section 12L regarding nonprofits to provide an advisory opinion due to a failure to meet preconditions.
Okay, let's double check to make sure we still have all the parties here. So is Mr. Petrellis still on the line?
Hello, caller. I've unmuted you. Is this Mr. Petrellis?
Mr. Petrellis? We can't hear you, so you might be muted. Oh, we have another hand up.
Up.
We can hear you now.
We can hear you.
Oh, great. Good to know you can hear me. Thank you.
Great.
Okay.
One moment, please.
We're going to elevate you to panelist, and then do we have someone from the Castro Community Development District here, either in person or on the phone?
We have Executive Director IAO.
Okay.
In the room.
Oh, in the room. Okay, if you wanted to step up. Okay, before we begin, I'm going to turn this over to Complaint Chair Schmidt to give us a quick rundown of where they were on this complaint. I think they just heard it a few weeks ago.
I'm gonna first. I'm gonna do somewhat of a comment, which is that this matter we thought was a no jurisdiction matter, and in my reading of the existing rules, I've always thought it was strange that the committees are asked to review jurisdiction, but it doesn't seem like there's any way to stop a case if there's a finding of no jurisdiction. It's just not, it's not clear. We are making a recommendation that there's no jurisdiction here, but we thought we couldn't make a final decision on that. So that's why this is here. The substance of it is that under 12L, there is a provision for this task force to have the ability to render an advisory opinion. And that could happen here, but there's a precondition, which is that Mr. Petrellis in this situation would have to get a denial and then complain about that denial to the city agency who administers the contract. And that did not occur here. So the precondition did not occur. And that's one of the reasons we believe that we couldn't do anything, at least under 12.4. We also looked at whether something could be done just under sunshine, and that's because they say that they will comply with sunshine. And so can we enforce that? And we did not think that was sufficient to give this body jurisdiction over this entity who's they are involved in a sort of a public-private realm, but they are not enumerated as agency. And so we did not think that we can take jurisdiction over them in order to give any kind of remedy in this case.
Okay. So I think, Mr. Petrellis, you're ready to go. So you'll have 5 minutes, and our administrator will let you know when you can begin.
Mr. Petrellis, are you ready?
Yes, I am.
Your 5 minutes begins now.
Hello, this is Michael Petrellis. I, first of all, very much believe that the city may have deliberately found a way to get around sunshine laws in creating more than a dozen community benefit districts. I brought this matter to the task force because I would like clarification and a decision made about any and all sunshine laws that may be applicable to not just the Castro CBD, but indeed all of the community benefit districts. And I am asking you to find that you have jurisdiction, that there is merit to my complaints. And I really do not think that the public needs to go to another city agency after they have been denied access to public records, that we then have to go to the Mayor's Office of Economic Development and file a complaint with them that we've been denied access to records. I believe I have stated in the past that the executive director of the Community Benefit District created a policy where she will take only a single public records request per month per person, and that we could only use one term for her to search. I find that is really not I believe it's a violation of sunshine. So again, I ask that you find jurisdiction and merit. Thank you.
Thank you.
Okay. Let's move to the respondent. You'll have 5 minutes. Once our administrator lets you know you can begin.
Good evening, Sunshine Task Force. My name is Andrea Aiello, and I am the Executive Director for the Castro Community Benefit District. And we're here to state that we believe that the Sunshine Task Force has no jurisdiction over the Castro Community Benefit District. Sunshine Task Force jurisdiction scope is the City and County of San Francisco. The Castro Community Benefit District, or the CBD, is a nonprofit private entity that is legally distinct from the city government and therefore not subject to the Sunshine Ordinance. The Castro CBD was established pursuant to the California Constitution and the Property and Business Improvement District Law of 1994, as amended and augmented by Article 15 of the San Francisco Business and Tax Regulations Code. The Sunshine Ordinance is not referenced in any of these laws or codes. The Castro CBD has a contract with the city to operate the property-based community benefit district, which outlines how property assessments are determined and those funds are utilized. The Sunshine Ordinance is mentioned in this contract as follows. Section 12.2, Sunshine Ordinance. Corporation acknowledges and agrees that this agreement is subject to Section 67.24E of the San Francisco Administrative Code. All information provided by corporation that is covered by such Section 67.24E and not exempt from disclosure pursuant to applicable law will be made available to the public upon request. The requirements of this section are in addition to the corporation's obligations to comply with the California Public Records Act. 67.24E is really about contracts, bids, and proposals. And we, the Castro CBD, we understand that the city will release information provided by us about our contracts, bids, and proposals in response to public records requests. This clause puts no responsibility on the Castro CBD. We are totally open and aware that our contracting process, RFPs, bidding process is open to the public, and that's what 67.24E refers to. We also understand that we are subject to 12L, and the Castro CBD complies fully with 12L. 12L is, hold on, let me get my notes. Um, 12L.4 is about public meetings. And all of our meetings are posted on our website, 72 hours. We comply with the California Brown Act, so all of our meetings are open to the public. And we take public comment before the meeting. We have general public comment, and we take public comment on every agenda item and before every vote. 12L.5 is disclosure of financial information. All of our financial information, our CPA review, our 990s, everything is on our budget. All of our financial information is on our website every year. And 12L.6 is about community representation, and we had on our board, and we do have a variety of people on our board. Our board is a community-based board, so we have property owners, we have merchants, we have residents, we have members of organizations that are leadership organizations in the neighborhood, and we also, at our annual meeting, on our agenda, allow for the public to suggest people to join our board. So we comply with 12L fully. And we also comply with 64.27E. Is that what it's called? 67.24E. So for these reasons, we hold that the Castro Community Benefit District is not subject to the Sunshine Task Force.
30 seconds.
However, we also understand that we are subject to the California Public Records Act and also the California Brown Act. That's the end. Thank you.
Okay, thank you. All right, members, any questions for the petitioner or the respondent? Do you have a question, Member Pilpel?
Yeah.
Go ahead.
So to Ms. Aiello, since she's standing here, nice to meet you.
Hi.
So I think I heard your testimony and I agree with some of it, but I'm not sure on a couple of points. The Castro CBD is subject to the Brown Act.
Yes.
Correct? Okay. And I recall this hasn't come up in a number of years, but I think there's some obscure Streets and Highways Code section.
Yes.
Related to BIDs and CBDs and whatnot.
Yes.
That had some weird throwaway line that said these entities are somehow subject to the Brown Act.
Brown Act and the California Public Records Act.
Okay.
Yes.
So that was my other question, that you're also subject to the Public Records Act?
Yes.
Okay, that I wasn't aware of, but okay. Same section, same concept?
Mm-hmm.
Okay. That's fine. But as a non-city entity, you're arguing that you're not subject to the Sunshine Ordinance.
Only as it pertains in our contract.
And in that way, it would be the city department that would be
Correct.
responsible, not the CBD. Okay. And then finally, on 12L, does the Castro CBD receive at least $250,000 a year? And which city department?
The Office of Economic and Workforce Development.
Okay. Is that still Lisa Pagan? Or
No.
it's somebody else now?
Somebody else.
Okay. So to the extent that Mr. Petrellis or anybody else is seeking to avail themselves of the 12L requirements, the precondition that was referenced in the clerical note is that they need to go through OEWD as the contracting entity, request whatever they want to request through OEWD. They will either provide or not provide and try to resolve. And if that doesn't get resolved, then it can come before us as a 12L complaint, but that hasn't happened yet. Is that essentially your position?
I believe so. I'm not an attorney.
That's fine.
But there is somebody from OEWD here who will be able to speak during public comment.
Okay. Could I ask that person now?
Sure.
Okay. Is this the non-Lisa Pagan person? Welcome. Okay. Problem with me is I remember all these things.
Hi, good evening, task force members. I'm Jackie Hazelwood. I'm the Community Benefit District Program Director with OEWD.
Okay. And you're the current person. Okay.
Yes.
So not all of the CBDs necessarily receive at least $250,000 a year from the city.
Correct.
But
yeah.
those that do would, by that arrangement, be subject to 12L. And as I asked a moment ago, if Mr. Petrellis or anybody else wants to avail themselves of the 12L process, they can do that through you with respect to the CBDs, including the Castro CBD. You would attempt to mediate, resolve, whatever. And if that's unsuccessful, then they can go through the process further under 12L.5 with us.
That's correct.
And that has not happened yet here.
Correct.
Okay. I think we're good.
Okay.
Thank you, Ms. Hazelwood.
Hazelwood. Yeah.
Very good. Okay. Thank you. Mr. Petrellis, since I just was the other side, do you have a different view to share with us?
At this point, no.
Okay. Have you or would you pursue the 12L avenue further?
Yes, there has been at least one instance when I made a request to the funding agency within the mayor's office. I believe it was to Chris Cortigas. It might have been to Ms. Hazelwood. So there was at least one attempt to obtain some public records from the Castro CBD through the funding agency.
Okay. And you understand that whatever records OEWD has or MTA or anybody else with regard to the Castro CBD, that would be subject to disclosure under a regular public records request, but there's a special process under 12L with regard to disputes. And you're somewhat familiar with that?
Yes.
Okay. So you can pursue that and bring this back to us at some point in the future if you don't resolve it with them. Yes?
Correct, David. Yes.
Okay. Thank you. I have something else for you later on in the meeting, but unrelated to this item. Thanks.
Okay. Anyone else with questions? None?
Member Highland here.
Okay.
Just want to make sure I understand that reading of of the 12L, 30 minutes, but not necessarily 30 minutes for one person. Am I reading that correctly?
I understand.
So I think what someone might complain about is if there were other people wanting to talk and only 6 minutes of the 30 minutes had been used up, ergo, they should have allowed more public comment. Because what Mr. Petrello seems to be saying is that he should have been allowed the balance of the 30 minutes, which that's how it reads in the.
Yeah, maybe Mr. Petrello, did you hear Member Highland's question?
Yes, and I would like to clarify at one point.
Please do. Yeah.
Please go ahead.
Yes. What happened at one of the board meetings is that there was a 6-minute total for all public comment speakers. And I am saying that they have to have at least 30 minutes of public comment, whether it's on item 1, 2, 3, or 4, that they can take more than a total of 6 minutes for public comment. They have not been going beyond the 6-minute limit. If there were, let's say, 5 items that a member of the public wanted to speak on and they were given only 2 minutes, that member of the public would be able to speak only on 3 items, 2 minutes total, and then the 6-minute limit that the CBD has set is then met, and no one else can speak. And I do not think that is legitimate.
Mr. Petrello, is this public comment on items or is this general public comment?
On items.
Okay.
All items, yes.
Okay. And they typically sounds like they allow people to talk for 2 minutes when they do select to talk on an item, right?
Well, let me tell you, they really bent that rule for one member of the community at their January meeting.
Okay. But you're saying that after
given way more than 2 minutes, way more than 2 minutes.
Right. So, but in general, they're allowing 2 minutes per speaker per item. But you're saying that
correct.
They're only allowing 3
but
speakers
if they meet,
6 minutes. I mean, if
there are 3 speakers on item 1 and each speaker uses their 2 minutes and you reach that 6-minute limit, when they get to item 2, no one can speak.
So
that's what's happened.
So, Mr. Petrello, are you saying that once they hit 6 minutes for the entire meeting, they don't take any more public comment? Is that the allegation? And
correct. And that happened at the October meeting.
Perhaps we can.
Can you clarify?
Yes. If you, our agendas are posted on our website. If anybody wants to look at castrocbd.org, clearly states that general public comment at the top of the agenda is limited to 6 minutes. The time can be changed by the chair. And we take public comment, additional public comment on every agenda item. So if you add all that stuff up, all those times up, there is a total of 30 minutes available for public comment if there are people who want to speak. We unfortunately don't get very many people coming to our meetings for public comment. So we someone speaks, they speak for 2 minutes. If there's another person, they speak for 2 minutes. If we had 5 people speaking about an item, they would be allowed to speak about an item for 2 minutes each. That hasn't happened in years.
I'm a little confused. I've heard this number described different ways by the different speakers. Where does the 6-minute limit, is it 6 minutes per item or 6 minutes per person?
At general, we can take it off the agenda. I just want to make sure that there's enough, that there's the 30 minutes. You have to have 30. We're not going to have each person speak for 30 minutes. Each person speaks for 2 minutes. And at the top of our agenda where it says general public comment, and you all know what general public comment is. It says limited to 2 minutes per person, 6 minutes total. I think that the complainant didn't read the rest of the agenda, didn't understand that each item that allows, each additional item on the agenda allows people from the public to speak on that agenda item and also before every vote. So there's ample opportunity for people to speak from the public to come and speak at our meetings.
Just a follow-up. Hypothetically, if I showed up at your meeting
Yes.
and there were 5 items on the agenda, would I be allowed to speak for 2 minutes for each of the 5 items?
Yes.
Okay. I don't understand the 6-minute limit at all.
That we have 6 minutes at the top.
Because you're saying you'll only accept public comment then from 3 people.
General public, we could take it off that we just want to get through the agenda. We don't want to be there. You know, we're all my board members are all
We understand volunteers. Yes.
Right. All volunteers.
Yeah.
And it's a struggle to actually find board members. So, you know, so we do say that at the top of the agenda, that general public comment is limited to 6 minutes. If that's wrong, that's wrong.
Okay.
But it also says that the chair can change that time limit at their discretion.
Thank you.
And let me have Member Highland.
So, Member Highland, I'm just going to go back to the fact that our complaint committee did not find jurisdiction in this. So we're not opining on the sunshine laws. We're opining on Brown and 12L. Is that correct? Is that what we're doing here? Because if this was 11 o'clock in another meeting, I would have shut this down by now because we did not find jurisdiction. However, since we're going down this path, we can opine on those lanes if we want to.
We can do one or two things, and that's a good question. So we can either, if you'd like, we could have a discussion now on the jurisdiction only question and settle that one way or the other. We've done this before, where we've just considered jurisdiction. We can make a ruling on that, and if we find that there is jurisdiction, we can continue into the details.
Okay, I'm going to say I respect the complaint chair's suggestion that we don't have jurisdiction. We've had this debate many times in the last year. These CBDs, we don't have jurisdiction, and I firmly believe that. I don't need to debate that. I will say that anything else we talk to or advise, this CBD is a friendly suggestion as to how meetings are run. They don't have to rise to that standard based on our purview, but I think they should take the 6 minutes off and allow as many speakers as happen to come by for the 2 minutes and then proceed like that. So that's it in a nutshell. I don't think we need to belabor this any longer, honestly. That's my position. Thank you.
Mr. Chair.
Mr. Chair.
Okay, just real fast. We're in the question part now. There's still a rebuttal stage. So before we take action, talk about what action we're going to take, I want to make sure that we direct questions to them. We'll move to rebuttals, and then we can just talk about how we want to handle the disposition of this. So, Member Wolf, do you have questions for?
I'll hold.
Okay. Member Pilpel, is it a question for?
I was going to go with Member Highland's suggestion a moment ago to just not find jurisdiction and shut it down. So if we can do
I think we should
rebuttals.
Yeah, let's go to rebuttals.
The point is, I don't want to get into the thing on the merits. I'm not prepared to hear it on the merits if the preconditions haven't been met. So that's why I'm with finding no jurisdiction at this time.
Just a question to the chair based on what the members have said. Would a motion at this moment be untimely based on
there you go.
What this case is a little bit unusual, but I wonder if a motion might be timely, which would be moved to find no jurisdiction.
That's the motion.
Don't we have to allow rebuttals?
I mean, I would feel more comfortable just hear the rebuttals at this point. It's 3 minutes each, and I think we could give everyone a chance to conclude what it is they want to say.
Let's do that.
I'd rather do that than procedurally go off path. It's only 6 minutes talking.
Withdraw.
Okay.
So it's only 6 minutes.
Well,
funny.
But what about Member Wolf?
What's that?
What about Member Wolf?
Oh,
no, I'm going to hold until debate.
Yeah.
Till deliberations.
Okay. So let's do this. Let's move on to rebuttals. I think we're done with the direct questions. So if we have, do you have a rebuttal, ma'am? You have 3 minutes if you'd like to present. You can give a 3-minute rebuttal to us if you'd like, as part of the
Like a summary.
like a summary, a concluding statement of the 3
Concluding
minutes.
statement, I believe the question before you today really is about jurisdiction. And I think we've established, or some of the members and the committee, the complaint committee did establish and pass that motion that the Sunshine Ordinance Task Force does not have jurisdiction. And it seems like that's the question before you tonight. And maybe other issues can be discussed another time. I don't know, but I feel like that is the motion. The Sunshine Task Force has had this issue before you in the past. In fact, Mr. Petrellis, the same complainant, took the Castro CBD in May of 2012 to the Sunshine Ordinance Task Force, and the decision was no jurisdiction. So I believe that that is really what you need to decide, whether you have jurisdiction or not. And of course, according to our contract, the only part of Sunshine that we are subject to is 64.270. Thank you.
Okay, let's move to a rebuttal from Mr. Petrellis for 3 minutes.
Hi, I just very much appreciate. Yes?
You're just a moment, please. Let me reset your time.
Yes.
Your 3 minutes begins now.
Thank you so much for hearing this matter at the Complaints Committee. Thank you also for all the time you all volunteer for this incredibly important panel that I believe is an integral component to sunshine and local democracy. And thank you for considering this matter today. I hope you will vote in my favor. Thank you.
Thank you.
Are you ready for a motion?
If you'd like to make one.
Okay. I would so move to find no jurisdiction in this matter at this time, so that Mr. Petrellis has the option to pursue the matter with OEWD, with the Castro CBD. If they can't come to a resolution, then it may be back before us on the merits, but that at this time that we don't have jurisdiction. Is that
Okay,
clear?
That's a motion by Member Pilpel. Is there a second to that motion?
Seconded by Member Highland.
Okay.
Comment.
I have a comment on this, and then I'll get to you, Member Wolf. Frank, I'm not sure I agree. We discussed the Epstein versus Hollywood Entertainment District business improvement case considerably when we held a similar type of hearing. I'm going to read a part of it here. This went to the appellate court in California. It says the Hollywood Entertainment District 2 Business Improvement District is a special assessment district in the city of Los Angeles. The Hollywood Entertainment District Property Owners Association, the POA, 26 United States Code Section 501c6 nonprofit corporation administers the funds the city raises through assessments on businesses within VID 2 boundaries. The money is used to contract for things like security patrols, maintenance, street, alley cleaning, and a newsletter. It goes on, but then it talks about essentially that the POA was not simply a pre-existing corporation which just happened to be available to administer for the funds. Instead, the records indicate that it was formed in structures in a way to take over administrative functions that we normally handled by the city. This is a Brown Act case, and it essentially says that the Brown Act would apply to this particular board of this POA. Now, we heard a similar case against the Mission Dolores Community Development or Green Benefit District Formation Committee. Now, the formation committee that we did hear this on is very different than the actual, the formation committee is talking about putting it up for a vote. They were trying to develop signatures, put all that together so that people in the proposed district could vote whether or not. Right. This is a pre-formation. That's where we ruled that we did not have jurisdiction. Now, the Castro Community Development District is post-formation. Now, this is something that has come into existence. So I don't think our past actions on the previous case that I think some of us might be thinking of should relate to this because these are two very different entities. I don't believe that when we, I was in agreement with the decision we ultimately made in the prior case, that I don't think the formation committee met this standard. I'm not convinced, I'm not saying it is, but I'm not convinced at this stage that the actual Castro Community Benefit District might not fall under what is in Epstein. So I think we should have a further look at that before we vote. I'm not saying it is or is not. I just think we need to consider that because this doesn't directly relate to the matter we heard a year or so ago.
What did they find?
They found that in that case that they called it a POA, and that the Brown Act did apply to the POA, and they found that they essentially, because the city was delegating some of the city's responsibilities over to this nonprofit, that the Brown Act fully applied, and that it should be treated as if it was the city legislative body. I see you. I have Member Wolf next, so let's hear from Member Wolf. Go ahead.
So I agree with you, Mr. Chair, and in addition, the respondent answered questions and responded to us in their testimony that they are subject to virtually all the sunshine laws, state and local. So how could they not be within our jurisdiction? The question here is whether the violation is appropriate or not. And we should be focusing on that at this point. They are CBD. They are now a nonprofit, and they have a city contract that's more than $250,000. They are subject to 12L, as they admitted. They are subject to the Brown Act. They are subject to the CPRA, and subject to sunshine in many respects. So how could they not be within our jurisdiction? We're not talking about some other law. We're talking about the law that's we oversee. So I think this motion is inappropriate, and I think the focus should be on whether there's an actual violation or not, and whether it's too early for it to come to us based upon the process under 12L. I'll stop there.
Member Popo, go ahead.
Okay, so to reiterate, I believe Ms. Aiello agreed that the Castro CBD is subject to the Brown Act, is subject to the Public Records Act, is a nonprofit, is subject to 12L because they receive at least $250,000 a year in city funds, but is only subject to the Sunshine Ordinance under 67.24E by way of their contract with the city that so specifies that any documents provided or exchanged will be made public, presumably by OEWD. So they are 3 out of 4, but not the fourth. And the fourth one is kind of important because are they subject to the Sunshine Ordinance? And my view is no, they're not, any more than any other nonprofit in the city, which is not subject to the Sunshine Ordinance, but may be subject to the 12L requirements. And there's a process there that would get them back here if they don't resolve a dispute. And then we can talk about 30 minutes or 6 minutes. And we've already spent more than 30 minutes, in fact, more than 36 minutes on this topic. And then we can provide an advisory opinion on whatever the substantive issues are. We're just not there yet. And all of these same principles, in my view, would apply with regard to your Buena CBD, all the other CBDs, the BIDs, the EIO IDs, whatever, all those crazy little things that were set up. And that's in part why that obscure streets and highways code section provided that these entities would be subject to some state laws. Just because they're subject to some state laws does not put them under our jurisdiction. The school district, the community college district, the San Francisco Health Authority, the housing authority are subject to those same state laws, but are not subject to our jurisdiction because they are not part of the city and county of San Francisco, that municipal corporation, and its direct specific tentacles. Thanks.
Member Schmidt?
There is a motion and it's seconded. I wonder if we could have the vote on that.
Yeah, we can have a vote if there's discussion now the motion is concluded.
Unless the deputy city attorney has something to weigh in on?
No, our position is consistent with what Member Popal has laid out.
Okay, if there's no other discussion, we can call a vote on that.
Do you want to call public comment?
Public comment?
Oh, public comment, yes.
I don't, we have Ms. Hazelwood with public comment. 3 minutes?
3 minutes, yep.
Are you ready?
Yeah.
Okay, your time starts now.
Good evening again, task force members. My name is Jackie Hazelwood. I'm the Community Benefit District Program Director with OEWD. So this office is in agreement with the recommendations of Committee Chair Schmidt and Member Sugarman and also Member Pilpel in terms of his analysis of this case before you, of finding no jurisdiction over the Castro CBD and no ability under Administrative Code Section 12L to provide an advisory opinion at this time. As referenced under Section 67.20 of the Sunshine Ordinance, the ordinance applies to city departments, which are specifically defined under the section as a department with the city and county of San Francisco. CBDs do not fall under these qualifications as they are not departments of the city and county of San Francisco and are legally separate entities. Further, CBDs in San Francisco are legislated under the California Street and Highways Code, also known as the California PBID Law of 1994. This legislates not only San Francisco, but other bids, what they're called PBIDs, CBDs, all across the state. So that's the specific section there. Section 36.612 of this code ultimately overrides the Sunshine Ordinance. And that's what Member Pilpel was referencing earlier. In any event, saying that CBDs must comply with the Public Records Act and the Brown Act, but may not be considered a public entity for any purpose. As such, CBDs are subject to both the Public Records Act and Brown Act, but not the Sunshine Task Ordinance. And so action, if any, that may be appropriate, as discussed here, as those preconditions should be met in terms of the complainant forwarding their complaint specifically to OEWD as the agency that oversees the contracts. Additionally, the task force can also, if they deem it appropriate, refer this matter directly to the city agency, in this case OEWD, to move forward with this complaint. That's all. Thank you.
Thank you.
Okay. Do we have any other public comment?
Members of the online community, if you'd like to make public comment on this item, please raise your hand using your phone to press *3 or the app. We have no callers in the queue.
Okay, go ahead and close public comment. I did want to just say something based on the public comment that we received. While I understand the assertion being made in public comment and everything that this is the state law governs this, I think it's very important to realize this is also actually in the San Francisco Business and Tax Regulation Code, Article 15, which talks specifically about the formation of business improvement districts, the role of the Board of Supervisors, what they can do, and it's just Section 1 said state law provides procedures to form property and business improvement districts and levy assessments. This article provides authority for the city to augment and modify those state laws, those state law procedures, by authorizing the Board of Supervisors to do any of the following, and then it lists a variety of them. So, personally, I appreciate the feedback that this might be a state thing, but I see this mentioned very explicitly in the San Francisco Business and Tax Regulations Code, and so I respectfully disagree and think that this is something that specific city law pertains to, and not just a state law.
Mr. Chair, I have a point of order.
Go ahead, Member Wolf.
We now heard from Ms. Hazelwood twice. She spoke as a witness for the respondent, which makes her a party. and would usually, under our rules, exclude her from regular public comment.
I think in this case, she didn't make a statement. A member, Pilpel, wanted to ask a question. More as a
They responded, introduced her, and invited her up to the podium.
That's because I asked a question and she responded to that question.
Was she not here to speak on behalf of?
That she was going to. I heard that she was going to provide public comment. Member Pilpel asked if she could ask her a question before the public comment period, but it was not part of that. So I think we're okay there. Okay. Any other discussion? Public comments closed, so I think we can move to a vote.
Taking the vote, Member Pilpel.
Aye.
Member Pilpel, aye. Member Highland.
Aye.
Member Highland, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Pass.
That's fine. You could pass through the next name.
Call her again later.
Member LaHood,
We'll just come back.
pass. Member Kumar.
Yes.
Member Kumar, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Highland.
I was the second.
Sorry. Member Wolf.
No.
Member Wolf, no. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Chair Yankee.
No.
Chair Yankee, no.
Now call.
Member LaHood.
No.
Member LaHood, no. Three noes, one absent, 6 ayes.
6 ayes, 3 noes, 1 absent.
One absent.
The absent Sugarman, it passes. Okay. So that complaint is concluded.
Wait.
Motion passes. So no jurisdiction was found. So we can't continue.
Oh, because there are 9 of us.
There's 9.
Right.
Yeah.
No jurisdiction at this time.
At this time.
They may be back in the future.
Chair Yankee,
Go
can
ahead.
I ask a question? I think we need more. Thank you. I think we need more information and guidance because you're absolutely right. Questions like this keep coming up and it feels fuzzy because, because of the city's involvement with these benefit districts. And I understand what 12L is for, but this does feel different, especially because they're already subject to CPRA and the Brown Act. And as such, it seems like, and aren't we responsible for enforcing those in the city? This feels
Yeah,
fuzzy. I think we need more guidance.
Yeah, I'm the minority on this along with you, but I do feel that this is a delegation of city responsibilities to a private entity.
Yeah.
And I think the Epstein case talks about that. That's all. That's my viewpoint on this, and I think in that regard,
This is that no judgment on the activities themselves, just trying to get clarity.
I mean, the decision's already been made.
Yeah, the decision's already
You
made.
folks don't need to stay.
Right, but this
Before
may
we-
be of interest to you. Yeah.
Why don't we ask for legal counsel's advice on that?
Vice Chair
based on-
Stein, did you have?
Yeah, I
It's-
just want to echo, I do think this is a tough issue because of the nature of certain public-private partnerships. It's clearly kind of a delegation of city duties and activities that sort of become enmeshed with these private groups. And there are versions of sunshine laws other places in the world where they say things like, oh, if there's substantial funding of, nonprofits by the government, they would be subject to sunshine laws, but we don't have something that says that. And when I look specifically at what's included in a policy body. I just can't in our law find something that would seem to cover these public-private partnerships. But I do think it's a problem. And I feel like for future sunshine laws, or if we were really to think about amendments, this is something that we should look at very closely. And especially things like the CBDs or things like the fine arts museums, where these these contracts have been written in a way that does make it kind of murky and hazy. But I'm just not seeing the affirmative descriptors that I would need to see to think of these as, bona fide policy bodies.
I agree with you on that. It's fuzzy, and because it's fuzzy, it leaves us in the lurch as far as how to rule on situations like this. And maybe one of the things we could do is make a suggestion that in future for contracts that it specifically say you will be subject to the San Francisco Sunshine Ordinance. And takes care of that fuzzy.
Let me just point out that with the SF Parks Alliance case or cases and the Mission Dolores Square case, we were talking about this issue, but there's also a separate issue that is very, very intertwined here, which is in this situation, if Mr. Petrellis had wanted to get documents from the district, he could submit a request to the OEWD. That's right. And the OEWD may or may not determine that they need to go to the district because the district has constructive possession of certain documents. And I'm not sure if that's what Epstein was about, but I do know that the National City case down in Southern California was about constructive possession of documents. And so it's not like there's no remedy here whatsoever. It's just sort of a different way to put the onus on the OEWD to find the documents that are, they're documents about a public issue, that they're about public, the conduct of public business. So just wanted to.
Just for the record, Epstein was a Brown Act case. So it was about the Hollywood Entertainment District not holding open meetings, not posting agendas, things like that.
Member Highland here. Now, just going to say, if you voluntarily took away that 6-minute language, probably wouldn't be a bad thing. I mean, if this law evolves down the road, I'm sure us or another body would look favorably on that for what it's worth. I don't know if your meeting's out of hand, but,
Mr. Chair?
Yeah.
Me?
Could you use the microphone, please? Thank you.
We probably shouldn't get back and forth with let's not.
I'm sorry.
Misspoke. You can make a statement, but I want to get back to the conversation. I remember real fast.
Yeah. There was some assertion that these community benefit district are under some jurisdiction of the California Streets and Highways Code. It actually isn't, according to Section 1511 of the Administration Code, where it talks about the Board of Supervisors may elect to use the procedures set forth in the California Streets and Highway Code. And then it goes on, notwithstanding the Highway Code, and then again, notwithstanding the Highway Code, again, notwithstanding the Highway Code, if the Board of Supervisors took some action that use these procedures, but it doesn't say that it's governed by that section of the code. So I take a little. I just wanted to bring that to light a little bit, because it brings it back to municipal and not necessarily governed by the state. It just allows the city to use an existing procedure or process that exists under some other code, so they don't have to reinvent the wheel.
Member Pippel?
I'm not debating any of this any further. I was just going to volunteer to, if I feel inspired in the next couple of days, to distill down to a page or two my thoughts on who very clearly is subject to the Sunshine Ordinance, who very clearly isn't, and for anything that's fuzzy and in the middle to try to suggest which way I would go on it and why. And we can bring that to a committee or back to the full task force, invite anyone who cares to talk about it, and maybe settle as much of the stuff that can be settled as possible and leave the debates in the future for those that are fuzzy or cloudy, but so that we don't have to reinvent the wheel regularly.
Yeah, I think it's a great thing.
The same darn
if
wheel.
you want to take it on, or if a committee wants to take it on, I think there's, and you're absolutely right too. I forget who said it. I think it was Member Hood about, we've heard this in various city, nonprofit partnerships, and each one seems to have its own unique way that it's
It was
involved.
Member Stein.
Oh, Stein, I'm sorry, Member Stein. Right, and each one seems to have its own unique way in which it's involved, whether it's the Fine Arts Museum or the zoo.
Yep.
Or this, and each one interacts differently with city law.
And there's a
And I'm
story
not
for all
sure,
of them.
yeah, there's a story for all of them. I'm not sure that each one necessarily gets the same application of the Sunshine Ordinance. So, I mean, it would be, I think, an excellent project if someone or some committee over the next several months wants to work. I mean, I think that's a great start. I'm not sure that a one-page document's going to cover the scope that this goes.
I'm willing to start, and if we have something that we can come to some consensus on, then I think we could forward that to the city attorney's office and ask them to review it. And if they concur, then maybe we've got, some general agreement around the world here. But one thing at a time.
Yeah, it's probably too late to do anything about it for this annual report, but I would also love for whoever takes that on to think about, articulating it as a practical and policy problem related to the Sunshine Ordinance, and discuss the problem in its, fullness, and then propose actual solutions.
Yeah, or maybe it even ends up as part of item number 9, and we actually write this more clearly into the Sunshine Ordinance. It speaks more clearly on the interaction of the Sunshine Ordinance with nonprofits. So it's not this unique path we have to go down every time, depending on which organization it is.
And I might reach out to Mr. Petrellis or the representatives here to discuss this further, unrelated to this particular case, but related to this larger question of jurisdiction.
Member Highland here. And just lastly, back to the original comment that Chair Schmidt brought up. We have a gray area as to the triaging of jurisdiction at the committee level, which I think we need to address in our policy. I mean, if it's, and part of that is, even our administrators do a little bit of that when they intake a case, right? Is there, no, this, you're in the wrong place, you have to go here. I mean, that's another step. Do we find jurisdiction? If we're not sure about jurisdiction, we could present it to the full task force, kind of like today. I mean, maybe today was one that could have been presented. We're not sure about jurisdiction. Therefore, we're going to elevate it. But if it's black and white at that level, the committee needs to have the power to say, we don't have jurisdiction, therefore this doesn't meet the criteria, therefore this does not advance, I think.
And I think I'm looking to see, do we have that written into our bylaws? I think there's something.
I think it's in our complaint.
Either complaint procedure or bylaws. And I think this is one of them I'm glad was moved to us. I think it spurred a very good discussion. But you're right, there's going to be ones where it's, Safeway. Well, obviously we don't have jurisdiction over Safeway, or, maybe even something a little bit less like that.
The city's going to pass a Safeway protection ordinance about the one on Webster shortly. So, blah, blah, blah.
We have
in the Safeway CBD. So never mind.
A little punchy.
Okay, it does say, it says that each committee can have hearings on complaints to review jurisdiction and the merits of the complaint in order to provide recommendations to the full task force. So we could probably have them put on consent if it's a simple jurisdiction thing. If it's a more complex discussion, I think this was handled great. I think we had a really good discussion and kind of took away something from it.
And my final comment on that is that wouldn't it be great if the contracts the city has with these different organizations was uniform in saying that you will be subject to the Sunshine Ordinance?
Or not, and if so, how?
Or not.
Yeah.
Right.
You will or you will not be. And clearly stated, not fuzzy, not we just ignore it, but in the contract. That could just be part of a regular contract that the city has with any organization.
And that's come up before in the context of the nonprofit contracting language that Peg Stevenson worked on. We've been through a lot of this before. So yeah, I agree.
Yeah.
Let's
Make
we can do this all night.
Okay, let's move on to item number 8.
Thank you.
Thank you, everyone.
Thank you.
Item
Thank you,
number.
Mr. Petrellis, too.
Thank you, Mr.
Thank you,
Petrellis.
Mr. Trellis.
From out of the country?
Yeah, Dominican Republic.
Enjoy your holiday, wherever you might be.
He is no longer online.
What did you say? He's a Dominican Republican?
No.
I think he's in Dominican Republic.
So
That's
he became a Dominican Republican.
Oh,
Never mind.
Too soon.
he lives there now?
I think it's too soon.
Too soon.
Visiting?
Just had
I mean, I don't know.
He's gotten out.
Too soon.
Item number 9.
8.
8.
Used to be 9.
Hearing update on Sunshine Ordinance Task Force's 2024 annual report. This is for discussion only. Members of the public and the Sunshine Ordinance Task Force can view the annual report proposal online. The link is in the agenda and it's searchable on our website. No password or identification is required. Public comments on this document can be sent directly to lstein, S-T-E-I-N, .sotf@gmail.com or made during public comment on this agenda item.
Okay, I'll turn over to Vice Chair Stein.
Yes, so I'll just say I've almost got all of the complaint processing data finished and ready to post. I'm just waiting on a few inputs, which I've been told to be in within the week or within a week on compliance. This year, I'm collecting information about wherever we issued an order to release additional documents or do something else, what we followed up with and whether that thing was accomplished or not. So that's taking a little bit of follow-up work, but that's almost done. I wanted to give an update on the survey. It didn't quite go out on the date that it was planned, but it was close. It went out on January 7th, and the final responses were due today which is January 21st, right? And I don't know, I haven't seen like how many responses came in or even know if anyone's looked at that yet, but I did see there's a bunch of emails to me today from different respondents because we also asked them this year to take a snapshot if they're on Next Request or Government QA to take a snapshot of their year's stats if they have the ability to look at that in a kind of header on those systems or a kind of metrics page of those systems. So some people are sending those in and those will help us kind of corroborate the numbers that we see, hopefully, but of course they'll be incomplete. I had given January 31st as the deadline to submit any practical or policy problems that you want to for endorsement by the task force. But now that I look at it, that January 31st, like normally when we send out the task force packet for a meeting, and we need to have everything 5 days before, I can't remember, is that 5 calendar days or 5 working days?
When the packet goes out, the requirement is 72 hours. What that means for publication purposes is that it pushes us to the Friday before.
Friday before. So I had originally said that was due January 31st. Well, that is the Friday before, I guess. So I guess we could keep that if we want. I wouldn't have time to review it if you wanted me to kind of review what you were submitting.
Yeah, I would, if I try not, they have a hard 4 p.m. stop on the Friday. So get the agenda to the library. If we don't hit the library deadline, we can't hold the meeting. So I would kind of operate on usually 30th.
Yep, our preference is for the Thursday in case something goes on.
And Friday's always like the emergency day.
Okay, can I ask if one, you can get your thing.
30th.
30th.
Yes.
And is there anyone else who's working on anything?
Well, I said I would get to stuff on Monday, but
Yeah, right,
that's
but not
yeah,
the
yeah.
practical policy thing. Okay. So if we got the practical and policy, any submissions by January 30th, then we could put them on the agenda for the February 5th, and we could maybe still make our original timeline to release the report on February 15th. However, if we miss that window to get it in time for the next task force meeting, then we'd be pushing to approve those by March 5th and trying to get the report out as soon as possible after that. I would love to get it out mid-February if we can work that fast. So again, that would be the January 30th deadline if you had any practical or policy issues that you wanted to submit. I will hopefully put up the complaint resolution data file as soon as I get it together, which will probably be within the next week. And as soon as I can get the survey data. I don't know if you have anything you want to add about the survey process.
We will have a second reminder going out to departments that we haven't heard from.
Oh, okay. That's great. So technically our deadline is passed, but we'll do one more last ditch effort, right?
Yes.
Okay. All right. That's great. So that's it, unless there are any questions or we want to hear any public comments.
Are you going to do the customer survey?
No, I haven't done it.
Okay.
I mean, there is a sort of survey on our website, but we didn't send out any email. We didn't discuss affirmatively doing that. Someone wants to take that on next year.
That survey is still active. It's on the documents page.
Okay. Any public comment
We have no one
here? Anyone online?
We have no one in the room. Individuals online, if you'd like to make public comment on this item, please raise your hand in the app or press *3. We have no hands raised.
Okay, let's go ahead and move on to item number 9.
Item number 9, hearing on Sunshine Ordinance amendments. Discussion regarding potential amendments to the Sunshine Ordinance and the related work of the Compliance and Amendments Committee.
So I'm going to just kind of keep this on as a rolling item. It doesn't mean we have to get into a long discussion, but I know you guys are doing a lot of work, and I want just you to have the opportunity out of your committee, if you ever have questions on, hey, we're considering this big topic. What do you guys think, that we can have that broader discussion? So I know we can't come to your.
Yeah, so we haven't met since you guys gave us comments last time. So I was going to bring your comments from last time to our meeting next week. And then I think we'll have more to say after that. Unless people have new ideas that they want to throw at us. You know, I took notes in December on, you actually all gave us some, or those who were here gave us some great sort of high level thoughts, which I think was really helpful. But I don't know if anybody has thought further, and Vice Chair Stein actually sent an email with some of hers written up. But I don't know if anybody has other things that they didn't get to mention before that they'd like to add.
When I just add that, you know, based on our discussion tonight, if there's a way, maybe that the interplay between nonprofits and
yes
could somehow be
yeah.
better described. I don't know if that means incorporating 12L in the Sunshine Ordinance, if 12L needs to be maybe written a little bit better, but there just seems to be a lot of, seems like a huge amount of our cases are these types of cases. And I know, you know, the complaint committee heard a zoo one, and they'll probably come to us next meeting. That's going to be another one of these types of things about to what level does the Sunshine Ordinance, you know, impact the zoo. We heard the Fine Arts Museum ones. This is just a very recurring thing. And if we can have something in the Sunshine Ordinance that, you know, that we could point to that more clearly describes how that relationship works, I think it'd be helpful for constituents, for departments, just for everyone involved.
On that, as I've been going through for my work for the committee, there are a couple of sections in the Sunshine Ordinance that I think are confusing, duplicative, problematic as relates to nonprofits that were either intended to deal with some specific problem or just create a whole nother set of complexities. The language about entities that are providing services otherwise provided by government and blah, 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 and record keeping and whatnot. My current feeling is that we should delete those provisions in the Sunshine Ordinance and rely exclusively on 12L as relates to nonprofits, and then have a document, whether it's mine or somebody else's, about what applies in specific cases, so that there isn't, you've got this, you've got to apply, but then this, except for that, but there's an exception to the exception. The more we can simplify it and say, you know what, if you get 250,000 from the city or whatever the threshold is, you're subject to these requirements. This is how it's laid out. Here's the guide to how to, implement 12L. That's it. If you're subject to Sunshine, whether you're a city department or not because you're the zoo or whatever, here's what you do, period, right? That there should be less gray. So however we resolve it, I think, intended ambiguity is fine. Unintended ambiguity causes problems.
Okay, anything else on this item? Public comment on this item?
Members of the public, if you'd like to make public comment, please raise your hand in the app or press *3. We have no hands raised.
Okay.
Mr. Chair.
Go ahead.
One last quick resource. If you are looking for coverage around transparency in the city, there's a website called openbook.sfgov.org, and it has some categories of information that the city has declared to be public. So I don't know if that's of any interest to anyone.
Thank you, Member Wolf. That's helpful. Okay. No public comment. I think we're done on this one, so we can move to item number 10.
Item number 10, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Okay. Anything for this item? Go ahead, Member Popo.
A number of quick items in the last couple of days as relates to the transition in Washington. There was some number of things going on there, but in particular on the Department of Government Efficiency, that's DOGE thing. There, I believe, is already a lawsuit on that suggesting that the way that it's functioning or has been may be subject to the Federal Advisory Committee Act. That's a federal law, deals with stuff that's not at all in our purview, but I was just going to flag that for the Deputy City Attorney and suggest that when something comes down on that, and it'll probably be a while and there'll be a complicated path, to let us know, because I think there are some concepts in there about who's in charge and how meetings happen and whatnot that bear on concepts that we have: passive meeting bodies, policy bodies, advisory bodies, who forms something, etc. So it may have some, it may be informative to us, not instructive, but maybe interesting. That's all I wanted to say on Washington. On the new mayor and members of the Board of Supervisors, I have no idea who's now handling Sunshine in the mayor's office. It would be nice to know that, and however we can find that out would be great. If an email or a memo from Chair Yankee to the mayor asking for who is their point person on Sunshine would get to that, and maybe invite that person to the appropriate place.
I was going to, during mine, I was going to say, I think it'd be, unless anyone had any objection, considering, I'll just kind of reach out to the mayor, say we want to, establish relationship. There's a lot of, places in the Sunshine Ordinance that the mayor's office plays a role.
Yep.
And also invite the mayor, if he would like to fill the ex officio seat.
That's where I was going as well.
Something we could have more direct feedback and communication with the mayor's office. I believe prior mayors,
Whether we
they feel
agree
that-
or disagree on
Right.
specific issues, but at least to have a line of communication.
and they can be here at our meetings and take back feedback. And I think that's much better than having, when we had Mr. Heckel show up
Yes.
just when the mayor's office was a complainant or a respondent rather. I think that'd be a lot more helpful.
Yes. And that was in part what I was going to relate to Mr. Petrellis, that somebody's going to replace Hank because I understand he's not there anymore. And similarly, whether it's formal or informal, reminding Angela Calvillo that she too can appoint an ex officio to this body. You know, we don't have to remind her every week, but
I've
often.
had that discussion with her.
Yeah, I know, but putting that in writing from time to time is not a bad idea. And same thing with new members of the Board of Supervisors, just to say we're here. It would be better to interact with new members and their staff before there's a complaint about their calendar or whatever. And so if they want to consult with us formally or otherwise, that might be welcome. You know, fewer complaints, more productive discussion. So that's the mayor and the board. And finally, since there was reference to Data SF a moment ago, the city, I saw recently, the city appointed a new chief data officer. I forget who it is, and a new director of COIT. And the new director of COIT, I recall, is Eddie McCaffrey, who's been around at a couple of different departments, most recently district attorney, but before that, I believe, was at assessor recorder. And so that's probably good for us to have somebody who knows something about Sunshine as the director of COIT. Those are my comments. Thanks.
Okay. One thing I just want to mention is that we are getting very low on our backlog complaints. I think we've mentioned this numerous times. We have likely a lot of room on agendas now for other topics. So if anyone has any ideas, you know, we've talked years about not having time to get to anything besides complaints, and we finally have that time to get to stuff besides complaints. And so, like I said, I'll keep, you know, we'll continue to have the annual report as an item until that goes out. I'll continue to have the updates on Sunshine Ordinance amendments. We can use it or not use it, but if it's on the agenda, it's always there for us. But if anyone else has any, either, you know, you want a recurring thing on here or you want a specific topic that we can discuss, just let me know. I'm free to add it, even for February. And remember, our meeting's only in 15 days, so that's it.
Item 11,
Public comment?
public comment on item 10. Anyone in the online community wishing to make public comment, please raise your hand by pressing *3 or using the app. We have no hands raised.
Okay, item number 11.
Item 11.
Move to adjourn.
We are adjourned at
Okay, with no objection, we are adjourned at 9:19.
19.
19.
Adjourned at 9:19 p.m. Mics are off.
Good to see all of you. Have a good. I'll see you in a couple of weeks.